Good morning, everyone. My name is Nika Mukherjee, and I would like to welcome each one of you to the Law Conclave 2021 today. This conclave was conceptualized with the core belief that the legal landscape is evolving, and we believe that each one of us stakeholders in legal education and legal practice is responsible to either drive the change or propel it. Globalization and technology are constantly transforming the global economy. The legal profession is no exception to this rapid evolution. The way legal services are delivered has changed, leaving many unsure what the future looks like for lawyers and how to prepare for it. There have been stark predictions for the future of law and for lawyers. The recurrent one being that next generation lawyers require a deep understanding of the law with a host of tech and soft skills to remain competitive because they will live in a global digital economy. Keeping this in mind, BML Munjal University, along with Vahura, a legal talent and consulting firm, conducted a research study through extensive engagement with experts in the industry, academia, and policy to understand the changing contours of the legal landscape and the need for legal education to adapt to the digital age. We shall be discussing the insights of this research study in this conclave as well. But before we start our day, I would like to welcome our special guests, dignitaries, and speakers who have accepted our invitation to be a part of this conclave today. I would also like to extend a big thank you to all our guests who are watching this conclave today, both on Zoom and on our Facebook page. I would now like to introduce our first dignitary, Dr. Manoj K. Arora, Vice Chancellor, BML Munjal University. I would invite Sir to please come and speak a few words. Professor Manoj Arora holds a PhD in remote sensing from Swansea University, UK. He was a postdoctoral research fellow for about 2 years in a NASA-sponsored project in electrical engineering and in the computer science department, Syracuse University, USA. He completed a BE in civil engineering in 1984 from Punjab Engineering College and a ME in civil engineering in 1986 from IIT Roorkee. He has more than 30 years of teaching, research, and administrative experience in academic institutions in India, UK, and USA. Over to you, sir.
Thank you, Mihika. Respected Mr. Sajjan, Senior Advocate, Honorable Supreme Court of India, Professor Roger, Mr. Mike, galaxy of panelists, participants, colleagues, and my dear students. I hope that you and your families are safe and healthy and keeping your spirits high in these difficult and testing times. What an auspicious day is today. Today is the birthday of our founder, Shri BML Munjalji, lovingly called as Dada Papa, who was born on this day in 1923 and left for heavenly abode on November 1, 2015. A legendary entrepreneur, a highly successful businessman, and a people's person. There are numerous stories about this towering personality. We all are blessed to be part of this great university nurtured by him. I'm very happy as well as excited to inaugurate the second BMU Law Conclave being organized by our School of Law and led by Professor Preetham Barua, the Dean, School of Law, and Professor Nigam, former Dean and advisor to the School of Law, both being renowned academicians and law practitioners. I, on behalf of BML Munjal University, welcome you all to this conclave. It is heartening to note that the conclave has attracted a large number of participations, even in these challenging times when the pandemic has impacted each and every family. This is a testimony of the importance of law in the country. The pandemic has also given the legal industry a rare opportunity to change the way we have been practicing and conducting the business of law. The magnitude of the change requires all stakeholders to contribute and participate. We usually talk of 3 change agents: people, process, and technology. No doubt, all 3 are interconnected, but perhaps it is the people who will bring the change when it comes to the use of technology and reforms in processes. Therefore, The theme of the second law conclave, that is, adapting legal education to digital reality, is very apt in today's context. This is the time for us when we upskill ourselves and adopt new ways of working. Collaboration and communication will now be the key to success. In the law fraternity, it is believed that lawyers are self-sufficient and have not welcomed or accepted multidisciplinary professionals that enable to deliver the best legal services to our clients. It is now time to change that perception and widen our perspective. As somebody said, that it is time for us to make space for innovators, legal technology specialists, knowledge management, marketing, business development, pricing experts, STEM professionals, and legal design thinkers. This, in fact, would require a complete rethinking of the law education in the country, which is sitting at the intersection of traditional versus digital law education. Friends, today we are living in Industry 4.0 era, which is an age of artificial intelligence and data sciences. Although we are just a 7 years young university, we have kept pace with the technology and have introduced a number of specializations like data sciences and artificial intelligence, data analytics, business analytics, digital marketing, Internet of Things, cybersecurity, automation, and robotics. Artificial intelligence, machine learning, data analytics, and predictive analytics have already begun to disrupt the legal market. I can see that. Remote working, online courts, digitized workspaces, e-libraries, case management, digital signatures, document management, and knowledge management solutions have suddenly become non-negotiable. You already saw a glimpse of all these things during our first law conclave on law and technology held last year. You would therefore agree with me that it is critical to completely revamp the law education and hence the curricula and pedagogical practices in the universities. We do need to produce smart lawyers or digital native lawyers, as you may like to call it. We at BML Munjal University believe in interdisciplinary education and experiential learning with the intent to provide lifelong learning skills to make our graduates leaders of tomorrow in their professions. Our first and second year law students have already made a remarkable impact by winning a number of moot court competitions while competing with fourth and fifth year students from other institutes of repute in the country. Our pedagogy indeed is making an impact. We are confident that our School of Law will be unique and different from other law schools in the country, and there is no rolling back. In this process, we have undertaken the first of its kind study titled Legal Curriculum Redesigned for the Digital World, which will be released today. The study sets out to capture how legal education can better prepare young lawyers for the digital world in the rapidly transforming digital and legal environments in India. The objective of this study has been to diagnose and define the gaps and formulate effective ways of restructure curriculum and pedagogy. BMU and Vahura explored the role of law schools and their curricula in preparing digital native lawyers. Lawyers who are at ease with the digital world and who are molded by such a digital world. One of the key findings of the report is greater collaborative engagement between law schools with other key stakeholders in structuring curriculum and pedagogy that is required to ensure effective legal education in the digital world. Friends, more secrets from the report will be revealed by Professor Nigam, Professor Preetam, Ritvik, and the team Vahura during the day. Clearly, the law schools must lead the knowledge creation on key intersections of technology and the law across sectors, thereby creating more opportunities for effective learning for students and training of faculty for the purpose of effectively discharging legal training. We have leading professionals and experts coming to our classrooms to interact with the students. Lawyers from leading law firms and academicians from foreign universities have addressed our students in their classes. Further, as we give a lot of importance to innovation and entrepreneurship. And in my opinion, every lawyer is an entrepreneur. Perhaps courses on innovation, entrepreneurship, design thinking, critical reasoning, coding skills will certainly go a long way in revamping the law curriculum. I'm sure that the finding of this report will further strengthen our belief and thinking and provide us leads to make continuous modifications in our pedagogy all the time. I'm confident that the second law conclave on the theme adapting legal education to digital reality will be able to address rapid changes taking place in the legal education and understand the role of law schools in developing future lawyers. Towards the end, I must thank Professor Nigam, Professor Preetham, their teams, the team Vahura, and our marketing team to organize this great event, though virtually. I'm sure that participants would enjoy the two panel discussions with a battery of experts. I wish all the participants the very best. Enjoy vibrant sessions lying ahead of you. Over to you, Mihika. Thank you.
Thank you so much, sir. It was indeed a pleasure hearing your words. I would now like to invite Mr. Mike Clark to come and address the audience. Mr. Mike Clark is the Chief Operating Officer and Chief Human Resources Officer of Hero Motorco Limited, India. Mr. Mike Clark did his mechanical engineering from St. Helens College of Technology, UK. He completed his bachelor's in mechanical and manufacturing engineering from John Moores University, Liverpool, UK. And from there, he subsequently did his MBA. He is a business leader with more than 20 years of global human resources experience in US and in UK's publicly listed companies. He has extensive experience in building, leading, and managing teams across geographies and functions. We are glad to have you here, sir. Over to you.
Thank you for that. Thank you for that introduction, Professor Manoj. Thank you for the invite. I'm really delighted to be here actually this morning, and I've been with Hero Motorco. We were just saying a little bit earlier about just on 6 months right now, and I'm based here in India. And it's been a delight to be part of the organization. It's great to recognize our founder today. What a brilliant day to have this conclave. The conclave itself, and to the professors, the faculty, the panelists, the students, you know, it's really great to see your industry actually looking forward and looking around innovation. I cover a little bit that later on in my discussion around how innovation in industry is shaping ourselves. But today's focus is about how technology will impact law. And in fact, the report that was being made reference to in terms of, you know, the legal curriculum in terms of its design for how it's going to shift to, you know, the digital world. And I won't be able to stay for the panel discussions a little bit later on in your day, but the two panel discussions, you know, centered around, you know, the delivery of legal services and also policy. It cannot be a really two good panel discussions that the tee up for that is so critical. You know, as a leader in engineering and in industry, I am delighted to actually maybe share some of the experiences that we're going through right now in the automotive industry. And it is a very disrupted area, but actually it's quite reassuring actually to look at your own industry. In fact, very recently, the former Chief Justice of India, S.A. Bobde, at a recent Supreme Court Bar Association, I understand he made a quote, and I picked that out this morning. I was quite interested to see that. He's actually, and I'll read it to you guys. He said, "We must increasingly focus and harness IT. IT enables services for providing more efficient, cost-effective access to delivery of justice." And I thought that was really a sort of enlightening as you start about, you know, streamlining the court process. And in industry, to be competitive, you have to actually streamline all the time. You have to look at continuous improvement to be competitive. And when you look at the technology, you know, even in my own short story here at Hero Motorcorp in terms of innovation and the challenges of that, let me give you a little story. I actually was speaking to our town hall fairly recently, all our engineers that we have in Jaipur. And we were talking about how to find time for innovation. And what I'm seeing in this right now is a great credit to you, because you are finding time to look at innovative ways and how it's going to impact your industry. I actually quoted on that. It was on the 25th of June, actually, if I remember well. I did this speak, and I look back in history, and on the same day in history, from an innovation point of view, in 1876, Alexander Graham Bell actually was presenting a new invention in Philadelphia, and I was using that as an example of innovation, how things have changed. And then actually he positioned the telephone on that day. And there was an exclaim coming out of the crowd. It said, "Oh my God, it talks." Well, when you think about how innovation has moved on since then, and you go to the automotive industry right now, which is certainly some of the context setting that I'd like to talk to you about as you go into the rest of your day. You know, the automotive industry, you know, I would say it's beyond the verge of disruption. We are looking at digitalization. There's increasing automation. New business models are actually being formed in industry, and even in the and especially in the automotive industry here in India. You know, we've all started to encounter the impacts of the global disruption. When you look at the key drivers in our industry around disruption, you know, there's four kind of key trends which are really impacting us, which is around electrification, it's around shared mobility, it's around connectivity, and autonomous driving. So those are the key drivers that are creating that disruption. If you look at electrification in itself, there's so many different forecasts of how EV will come to the market, you know, by 2020, 25, 30, and going beyond. What's really going to happen is the fact that we have to adopt that change. And the reality is that there will be more EVs coming into the market, which is great, because in fact, that's going to do many, many different things to enhance mobility. And as we are in Hero MotoCorp, our vision is to be the future of mobility. So it's so important for us in our industry to embrace that shift. Shared mobility, you know, in terms of looking at car sharing, bike sharing, ride sharing. And I think for students who are on this call today, I think you're already probably embracing some of those modes of transportation. Connectivity is another area that is key to us, as I mentioned, and this comprises of many, many different aspects, but it's about navigation, remote diagnostics for maintenance, telematics, and insurance solutions and driving assistance. So, and then we go to autonomous driving, which I meant. So they are the key changes that's driving disruption. And as you think about your own challenges in your own industry for that disruption, is how do you get ahead of the curve? If we look at our industry in terms of the EV, the startups, with those lots of new startups. So the fact that Hero MotoCorp has, you know, produced its, you know, 100th million vehicle, that doesn't give us the credits to be successful in the future. It'll be something that we can build upon. So most importantly, build upon our constant changes around the competencies, having the right assets that will allow us to be an automotive player in the future. And that comes right back down to what Dr. said at the beginning. It's around people. So understanding the skill sets of our people and driving those skill sets that will allow us to be taking on those challenges, but creating the challenges into big opportunities. And if we look at Hero MotoCorp right now, we're shifting those challenges to be opportunities. And I think that's the embrace that we have to go towards. If I look at the improvement in performance, if I look at the automotive industry in terms of the shift in our disruption, there's many areas around productivity, where technology, we're already embracing that, around sustainability. But also in the new area, we've got to be more thoughtful about how batteries, EV components in India will figure out in our strategies. And so we're all learning that together. It's a brand new playing field. And in fact, when it's a brand new playing field, it gives you that great opportunity to be ahead of the curve. And as students who are going to be embracing the rest of today, it's getting ahead of the curve and actually seeing, what do I need to do as a law firm or a practice to get ahead of the curve, to embrace the changes which is coming. You know, in terms of conclusion for our industry, you know, the move to e-mobility, the future technologies, it's inevitable. It's going to happen. You know, it will bring challenges. And as I said, it's going to bring those opportunities. to the automotive industry, and to the broader ecosystem, our supply base, our dealerships. To reap that and embrace that, it'll be a competitive edge for us, and a concerted effort by all of our key stakeholders to help the future of mobility solutions to be more of a self-sustaining and profitable market in the near-term future is the way we're going to go about that. So when we look at those challenges ahead, and I think the fact that we have those challenges, most importantly, which I would ask you all to think about as you start about your challenges, what are the scenarios? Scenario planning is super critical when you're in a volatile, uncertain, complex, and ambiguous situation. Planning out those scenarios is super critical for your success. Look at what the future can look like. Assess your current capabilities, which I think this is going to be an important conclave as you think about reshaping the education that's important to have our future law practice individuals to be ahead of the curve. Embracing and understanding the weak spots. So what is that gap that you have to fill? If we look at an industry, we're always looking for those weak spots to improve and fill those gaps in place so that we can remain competitive. Embracing agile, embracing customer-centric, data-driven approaches is super crucial. Whether we're in the automotive industry or whether we're in the law practice, those aspects of agility, customer-centric approaches, embracing data-driven approaches will make your success. So finalizing the maturing capabilities of you as students, as you as a faculty, and as professors, that maturing of those capabilities as you start to embrace what technology impact will have is going to be your success. Already, Doctor, you named numerous I guess new technology practices that are taking place in the law industry. I won't add to your list. I had computerized filing, the e-filings, digital signatures, active voice response systems. However, what I would also say, be aware of some of the new practices. I mean, already there's a Canadian-based company called Kira that's looking at machine learning software that will analyze illegal documents. How will that actually make your practice more and more efficient? There's also other startups called Legal Mind that's looking at AI actually to look at prediction and also look at conclusion in case law. So there are many, many aspects, and I actually embrace them in industry. I encourage you to embrace your own changes. And I wish you very well for the rest of your conclave today. And again, it's an exciting moment and also a challenging moment, but take every these as key opportunities. Thank you very much, and I'll hand back to the team.
Thank you so much for your words, sir. Moving on, BMU, in association with Bahura, conducted a qualitative study titled Legal Curriculum Redesigned for a Digital World. The study captures the perspective of the practitioners, policymakers, and academics about the redesigning of curricula in law schools in the context of the rapidly transforming legal industry. I will now request Mr. Ritvik Lukos, founder and CEO of Bahura and Council-elect, and Dr. Nigam Nagehali, professor at BML Munjal University, to share the key takeaways from the study.
Thank you, Bhika. I'll just wait for the video to come up. Great. Just checking if I have access. So I'd like to thank the BML Munjal University, especially Professor Nigam and Professor Barua, for initiating this study. Like Dr. Arora mentioned, this study is in a sense part 2, because last year we looked at the impact of technology on the practice of law. And what became quite clear is that this impact has moved from the periphery to the core. And one striking stat that came out was that half of the law firm and in-house practitioners expect that about 1/5 of their work will be taken over by technology over the next 5 years. So last year's study, then naturally raised the question, how should law schools respond to this emerging reality? And that's really the foundation for this study. And we really start with two hypotheses. The first is what emerged from last year's study, which is that technology is going to impact the delivery of legal services, but also the substantive law itself is undergoing a lot of change. Mike mentioned EV or autonomous driving, technology in the real world, in the digital age, we're seeing so much impact, biotech, and all this is impacting contracts, constitutional law, property law, intellectual property. So the substantive law itself is undergoing change. The second hypothesis is that there is a gap. Really the focus of the study was to understand what these gap areas are. So the objective was to map out the gaps and then explore ways in which that law schools can redesign legal education to bridge these gaps. This year, we followed a qualitative approach. And in a sense, we picked 20 experts who are working deeply at the intersection of technology and the law. It could be from a policy perspective. We spoke to practitioners, academicians from India and overseas as well, and innovators as well. So both entrepreneurs as well as justice innovators. Some of these faces will be familiar to a lot of our audience. I won't go into each of their names. We have their bios in detail in the report. But a quick snapshot, we have general counsel from Hindustan Unilever and ICICI Bank. We have partners from leading law firms like Trilegal, Indus Law, Samvad, Panang and Babu. We have constitutional law experts, securities law experts, leading counsel, policy experts from Google, Internet Freedom Foundation, the Apti Institute, and innovators and entrepreneurs from Agami, from the Hague Institute. We have a corporate lawyer who's now an engineer in Google. And most importantly, we have academicians from Harvard, from the IE Law School, from the IITs. And today on the panels, after this, we will hear from some of these experts, and we've broad-based that to include a few more experts as well. So that's really the approach that we took to really talk to each of these experts, and the findings have come from that process. So how is law school curricula falling short? Is it falling short? What came through quite clearly is that there is a gap. There is a gap that exists between academic instruction and the expectations in the real world. Interestingly, the practitioners emphasize that there are gaps in fundamental areas as well. So the traditional skills of drafting and legal research continue to be gap areas. One aspect here that's important is that they expect the lawyers coming out to also be adept at using tools, whether it's a drafting tool, whether it's a legal research tool, to be much more adept at using these tools. And the practitioners also emphasized the lack of skills, more contemporary skills like project management, business skills, client skills, and people skills. The policy experts we spoke to also spoke about the traditional area gaps, but emphasized the importance of communication, especially to a non-legal audience, and people skills as key gap areas. And our innovators highlighted empathy, putting yourself in the shoes of who you're serving as an important skill area that remains a gap. So the gaps in professional development, first and foremost, there lacks a fundamental understanding of technology and its interplay with society. And that fundamental grounding is important to be able to apply that to to law and policy subjects. Second, appreciation of electronic evidence and research skills and drafting, like we mentioned. Finance skills, understanding money, the flow of money and transactions, creative thinking and design thinking, and having a solution-oriented approach. The thing with technology is that they say that the more things change, the more things stay the same. So in many ways, as technology starts to take on the transactional tasks, the more mundane tasks, the interpersonal becomes that much more important. Right? The lawyer becomes that much closer to the client. So these personal development skills and competencies, the gaps become all the more glaring. So whether it's communication skills, leadership, entrepreneurial vision, people skills, ethics and integrity, and empathy. So is there a need to redesign law school curriculum and pedagogy? A majority of the practitioners said yes, that they should be redesigned. All the academicians and the policy and innovation leaders as well stated that there should be a redesign of legal education curriculum and pedagogy. So in terms of how legal curricula should be redesigned, I invite Professor Nigam to take us through the findings.
Thank you very much, Ritvik, and welcome to all the participants in the audience. Let me see if I can just move the screen around. Just give me 1 second, please. Yes. So, how should legal curriculum be redesigned? This is something that Ritvik has already alluded to in a little bit when he discussed the foundations of the report and what led to this process. This is personally something that I've really looked forward to since we ideated this idea together with Bahura in the last couple of years. We have been concerned that law and technology is an area that's been somewhat left unheeded by the law schools of the country, and we wanted to see if we can do something about curriculum and pedagogy in relation to law and technology, after having discussed how technology is revolutionizing the way legal practice and in fact law and policy are being conducted in today's society. Right? So it's in that context that that we are here before you. We are at the end of this summary of the report. We will officially release the report for everyone to see, and some of the themes that Ritvik and I have discussed in this presentation will then be taken forward and discussed at length in the two fantastic panels that we have today. I'm really looking forward to hearing the speakers on that panel as well. So the way we want to propose doing these changes is to begin with certain structural changes to the curriculum. And as I said, many of the things that we're discussing here will be discussed in more detail, I'm sure, in the panels, but also in the discussions thereafter. So among the changes that were discussed by our experts, several suggestions included changes that must be inculcated at a structural level by law schools, and which should define the approach taken by the institution while designing the curriculum and the pedagogy. And once you go through the report, you will notice that some of these structural changes are at the heart of how we should be teaching our students. The first thing we were looking at were greater engagement and collaboration between academic institutions and practitioners. And we would like such collaboration to drive curriculum redesign right from the very beginning. Such collaboration should also include pedagogical changes wherein course modules are taught by adjunct faculty. Now, this is something that we are really interested in, both in terms of legal curriculum design, but also in furthering the philosophy of the BMB Law School, where we believe in experiential learning. But of course, experiential learning is something that has to be concretized in some way, and we would like to go down that path when it comes to legal curriculum redesign here by inviting technologists and technology lawyers to play an integral part in the way we teach our students. Multidisciplinary teaching to be effectively harnessed. Suggestions in this regard included the introduction of course flexibility in the law school curricula and the teaching of non-legal subjects by faculty belonging to these disciplines, among others. Once again, we want to harness the kind of organic capabilities that institutions such as the BMU have. We have an engineering school and a management school, and we would like to ensure that there's some kind of multidisciplinary integrated approach to teaching law as taking advantage of our school. But I think the issue about multidisciplinary teaching goes beyond utilization of schools. It's actually a mindset. It's actually trying to figure out how to ensure that technology is taught to law students, not only from a legalistic point of view, but in its own right. And I'll come to that in a bit when I discuss the more concrete examples of what I'm talking about. Other suggestions included the creation of an environment where students can learn the interplay of technology and the law in their own way, and the setting up of what we call tech farms, or what other people, all the experts have called tech farms and labs. Basically experiments that the law students can do in order to kind of better grasp the interplay of technology and the law. Our experts also emphasized better training of faculty, increased research and development efforts by greater institutional engagements and collaboration with other industry stakeholders. And I think that's very important for us going forward, because while we speak about changing curriculum, we need to understand, as other people have acknowledged, that our faculty have to be trained and have to have the same kind of mindset that we're talking about, which will result in good training and good instruction in law and technology. So a snapshot of the core changes that we believe should happen to the legal curriculum. We first compulsory courses to inculcate a foundational understanding of technology, elective courses, extracurricular and co-curricular modules on interplay of law and technology, and then integration of a technology context in all our legal subjects. When we say compulsory courses, we meant that experts suggested the introduction of courses such as science, technology, and society, history of technology, data and society, technology, culture, and economy. Several practitioners recommended the law students be taught basic courses of technology, including basics of coding, so that they can understand algorithms, and recommended complementing such courses with math and economics. That almost all the experts suggested that compulsory foundational courses on technology be introduced during the first and the second years of the 5-year undergraduate law program. We agree that law students must integrate a technology context to legal subjects, and this can be done by way of case studies or legal clinics that involve deliberation of legal issues in technological contexts. Experts noted the importance of well-trained faculty and a collaborative engagement between academia and industry to bring this in effectively. Of course, I must emphasize at this stage that introducing technology context to legal subjects is not an easy task. It's not easy to tell faculty to teach contracts from a tech perspective, or property or constitutional law from a tech perspective, but I think we have come to a stage where we need to do that. In fact, I think Professor Brownsworth on the panel that we're going to have after this will probably discuss a few of those things. He has discussed law 1.0, 2.0, 3.0, and he has some very interesting things to say about contracts and how contracts and technology have to be taught very differently from what is being taught in law schools today. So I look forward to hearing on those issues. Similarly, if you talk about constitutional law, traditionally constitutional law courses in India have underemphasized the importance of privacy, and we have somebody like Rahul Mathan in our one of the panels who I'm sure will talk a little bit about what privacy means in the modern context. He's written a book on it. I think we look forward to hearing those kind of issues. And that's the kind of thing that we want to do in our legal subjects, to kind of ensure that when our students learn the law, they learn it keeping in mind the fact that the larger economy has now become mainly a tech-based economy. In addition to that, elective courses like innovation of the law, data privacy, smart contracts, etc. Specialized courses and executive education programs on data visualization, introduction to computers, law of technology, legal project management. These are all issues that are that are actually crying for expertise and for instruction. And this is something that we need to really think seriously about. We also would like our students to ensure that there are take part in legal clinics, tech farms, moot courts, discussion of case studies with technology contextualization. And this is again something that we need to encourage our students to do so that they're comfortable with this kind of interplay between law and technology going forward. Pedagogical changes, courses taught by practitioners as adjunct faculty in the form of guest lectures and seminar courses, maintaining an effective balance between theoretical and practical learning. One of our experts said that practical learning is good, but we need to ensure there's proper theoretical concept and understanding and underpinning this practical learning. And the theoretical concepts we're talking about are concepts that are informed by technology. Right? So there's a theoretical part of technology that's equally important, and that needs to be important. Rethinking legal education delivery in an information age through the increased use of multimedia, alternative modes of assessments, among others. Legal education delivery is increasingly important in the post-pandemic age. In fact, I see one of the questions on the panel asking, well, what do we do about the fact that students and teachers are kind of distanced from each other? They're just working through emails, but emails are merely post boxes. Those are the issues actually that we hope the panels discuss today, because that's part of what we believe should be addressed when we talk about legal education delivery. And of course, as I referred to earlier, setting up innovation sandboxes and creating student-friendly environments for learning and engaging with technology. So what we are driving towards is in digital native legal profession, right? Some student who's comfortable with technology, who believes not just that technology will basically drive the economic forces in going forward, but is also ready to deal with all the kind of entirely different legal changes that are going to come as a result of a change of technology. And that's what we mean by a digital native legal professional. He or she is going to go beyond the traditional parameters, the traditional structures within which we imagine law, and is in fact willing to go beyond that and try to see how we can both regulate technology on one hand and enhance legal practice on the other hand. This has been alluded to before, but I would just want to emphasize once again that we are looking at not just the traditional skills and competencies, which remain important, but also look at the new skills and competencies related to design thinking, legal risk management, a functional understanding of technology, project management, computational thinking, issues that are coming to the fore today, but which I believe law schools are yet to respond to adequately. So we invite the audience here to join us towards a new paradigm for education in our country. What that paradigm is still taking shape. The report that we are going to see today is just one step towards that new paradigm. The new paradigm has to be built by us, you, me, academics, policymakers, lawyers, students. And once we start working together and start thinking seriously through those kind of issues, then I believe we will be in a position to draw a new curriculum and a new kind of pedagogy for legal education. So with this, I come to an end of our joint report on legal curriculum reforms. And just to introduce a note of formality in these proceedings, I would like to say that we officially launch the report, Legal Curriculum Redesign for a Digital World by the School of Law, BML Munjal University, and Wahura. And I would like to now invite Professor Barua to say a few words on the report. Thank you very much.
Thank you, Dr. Nigam and Mr. Lucas, for giving us the key findings of this report. And as I read the report a few days back, and as I heard you today, I saw that the report presents both an emerging consensus and also some latent tensions which are rooted in the relationship between law and technology. And I think that's great fodder for our panel discussions today. And apart from the key findings which have been presented by the two of you, it seems that the report plays an important role in gathering hitherto dispersed voices who are key stakeholders, arguing for a consensus which is specifically related to legal education. I think that is something which we must all take note of and reflect on seriously. But it also made me reflect on the relationship between law and technology. And as much as, the two domains are very similar, right? They are both instruments of design, of facilitation, and of control in many different ways, sometimes through coercion, sometimes through other regulatory means. And both operate on almost every aspect, or at least claim to operate on diverse aspects of our lives. And therefore, I feel that what the report does is also shows that this relationship is symbiotic as well as competitive. Symbiotic in the sense that technology facilitates the law in many ways. It guides legal policy. It presents challenges to the law trying to play catch up. But it is also competitive because technology regulates the world, which is the turf of the law. So, and in that sense, when we introduce law and technology to our students, undergraduate students especially, I think the perspective that we adopt, we need to decide on that. It's important of how we start introducing, law and technology to our students. And therefore, I think that perhaps in our panel discussions today, we will be looking at some of the challenges that this presents to us. So we may all agree that technology is something which should be integrated into the curriculum, but there are some challenges which are peculiar to technology. For example, technology is really wide. So if we think of cognitive expertise over technology, then that seems almost not possible, right? It's such a wide domain. So in terms of education and from a knowledge perspective, how do we think of introducing technology to law students, knowing very well, as one of the interviewees had pointed out, that it's difficult for lawyers to become technological experts, but they must be aware of it. So how do we bring that out? Because these are two distinct roles somewhere. At the same time, I also think that there is a traditional problem, which is that of interdisciplinarity, which Dr. Nigam pointed out. Law schools have struggled with really being interdisciplinary. It's happened with history, it's happened with economics, and now technology is one of the other challenges. So we should be thinking about some overriding principles that must guide our integration, laying the foundations, and having electives which make lawyers technology educated. And we must reflect on those challenges. And the other thing which came to mind was that perhaps we can learn from what education did with gender studies, with sustainability studies, which are actually sensitizing the entire program towards these broad areas which govern almost every aspect of our life. And technology is one such thing. So I really look forward to the panel discussions today, because there is a lot of consensus, but also some disagreement. Great for a discussion. And I look forward to the discussions that later in the day. So thank you very much. And over to you, Mehika.
Thank you, Mr. Lucas, Dr. Nigam, and Dr. Barua. Taking it forward from here, we have some very interesting discussions lined up for you. Our first panel for the day is about practitioners and legal tech. Lawyers today must be equipped with the relevant knowledge and skill sets required to tackle and navigate the legal issues arising in the digital world. However, there seems to be a gap in the skill set that the students develop at law school and the skill set that the practice of law actually demands. There is a need to formulate ways in which law schools can, by way of a restructured curriculum, bridge this gap. Our first panel for the day comprises of practitioners of law who shall be discussing the ways to bring about this transformation in the legal curriculum. Allow me to introduce you to our panelists for this discussion. Mr. Rahul Mathan, founding partner at Trilegal, Ms. Chittu Nagarajan, Managing Director, Contract Wrangler, India, Mr. Somasekhar Sundaresan, Independent Counsel, Mr. Pramod Rao, Group General Counsel, ICICI, and Ms. Vrinda Bhandari, Independent Legal Practitioner. The discussion will be moderated by Mr. Aditya Rathore, Assistant Professor of Law, BML Munjal University. Over to you, Professor Rathore.
Thank you, Mehika. I welcome all the panelists to this panel discussion. This has already been mentioned at least twice. Mehika said it, and it was mentioned by Mr. Lucas when he was explaining the key takeaways, that there exists a gap between what is being taught at law schools and what the practice is demanding. So the idea behind this panel discussion is basically to acquaint ourselves about why this gap exists, how we can plug this gap, and also to get an idea of what is legal profession moving towards, like in which direction is it going? So what can we expect in future for which we need to start building from now? So without much ado, let me just explain how the next 15 minutes of panel discussion will be. The format is we will have comments from all our panelists. There will be 2 minutes given to all the panelists to give introductory remarks. Post these introductory remarks, I would be directing specific questions to each of the panelists. And once a panelist has responded to the question which is directed to them, others can comment, and if they have any additional inputs, they can give inputs. And once all the questions have been taken up by the panelists, I would then move on to Q&A, where attendees can post their questions. The attendees can keep on posting questions. I'll keep a track of it, but I will ask them towards the end. So welcome, panelists. I would request, Mr. Martin, would you like to go first?
Sure. So first, look, thank you for doing this. Thank you for taking the effort to actually think about the fact that as the world goes digital, we have to rethink the way we teach the law. I've been doing this law and tech for about 25 years now, and it's been very lonely except for the last 5 years or 10 years. And now it feels like everyone and their dog wants to be a tech lawyer or do something with tech. And I think that the law schools sort of are lagging a bit behind that. But if you ask me as a practitioner, what would I really like law schools to do? Every law firm, every senior counsel wants well-cooked lawyers as their associates and their juniors. And whatever we can do to make these lawyers sort of good, well-cooked lawyers for what we want is what we need. And I was just listening to some of the comments earlier. This is exactly the direction I think we need to be going, which is, and I'll speak about this more when you direct the questions to me. But I really like the framing of technology context, because we really don't want to make lawyers technologists. We don't want to, if you're doing legal education, actually train people to code. I mean, you want them to, so I don't want to say you don't want to code at all, but you need to give them context. And I think what we lack from associates who come straight from law school is context. Sometimes, and in the previous world, it used to be context, which is business context. But in this world, we really need digital context. And we want people who can just understand that the digital world works very differently from the real world. So, I would really like to drive home that point about context. I think it's extremely powerful.
Thank you, Mr. Martin. Ms. Nagarajan, your introductory remarks.
Yeah, hi everyone. As Rahul mentioned, thank you for bringing technology into the legal education. I've been in the field of legal tech, I should say, even though I come from a legal background, a law background, but I've been in the legal tech industry for over 20 years. And when Rahul said it's been very lonely, I think he's talking more from I think the practice area, but I am talking more from the legal tech area, where we were introduced to technology really early. I think one of the few things is when I started my legal tech company, my first company, I was the only one who knew anything about law, but then I had a whole group of technologists with me helping me, and it's scary. And then right through my years, I've been over here, and still we have very, very few people in the company who actually have a legal background, even though we run a legal tech company, right? So I think it's extremely important that people, just students who come out from law schools, start looking at careers outside of just practicing the law. There's a lot more things out there. The legal tech industry, which I will talk about later when you're directing the questions at me, as how big that industry is. We need to equip our students who are coming out for that industry. Also, when we are practicing law, technology is just inevitable right now, and the future of education, legal education, and future of humankind itself are millennials, right? And they are completely different. They are born with technology. So I feel that when they come into, and we do hire lawyers, but when they come into an industry, these millennials who are grown up with technology, they actually lose out because of the education which is given, and we are not actually being in par with the generation. So I think actually we are doing an injustice to them when we are teaching them and not in par with what they're used to. Thanks.
Thank you, Ms. Nagarajan. Next, may I please request Mr. Pramod Rao?
Hi, good morning to all of you. It's a pleasure to be here, and I'm yet to go through the report, but in both hearing the opening remarks and so on, I think I wanted to make a few comments, both to contextualize it in context of how we at a bank, or especially at a corporate, look at technology, and how we end up looking at lawyers and so on interacting with. I think the march of technology has been dramatic, as Rahul says, maybe last 5 years, but I can assure you that, last 20 years there's nothing which has stopped surprising me about what technology can do and accomplish. And it's really been as dramatic as democratizing access to finance. If you think about how people can today do securities trading, to me, it was something I got firsthand experience in working on ICICI Direct, and that was almost 21 years ago. And to me, that we introduced online securities trading here in the same vein that probably E-Trade was making debut in the US, sort of tells you that we are not far behind at all on technology or its adoption by the business. But what it also means is that the lawyers, whether in-house, whether the law firms we work with, or practitioners that we engage, need to be abreast of what we accomplish with that technology. How do we deliver it? What is it that we offer our customers? What can be the customers' grievances against us? I think each of it is interlinked in many ways. And we end up shaping the technologists as much as they end up telling us what the technology can accomplish. And I think that's been the joy of the journey, and which I would, sort of encourage young lawyers, young law students to sort of think about, that these interactions are still being shaped. They are by no means cast in stone. They are by no means final. And because technology is ever evolving, because societal expectation of that is ever evolving, I would tend to believe, we equally as lawyers have that opportunity of shaping it and, taking part in that. Just as an example, and especially since Chitu is on this panel, ODR, and it was something that we again exploded in the country in the last couple of years. But Chitu has been at it in I think for the last 20 years. But if I had to just again sort of reframe it, when I sort of just inquired around the 15 or 18 countries that ICICI Bank operates around, And the question to my teams in those countries was that, can we take ODR there? And it appears that probably India is at the cutting edge of those adoption, as opposed to even countries like the UK or Canada and so on. And that should tell you something, right? So to me, genuinely, this is the opportunity that lies ahead. Let me stop here and hand back to you, Professor Aditya.
Thank you, Mr. Rao. May I please request Mr. Sundaresan?
Thank you for having me. I just want to make a very few brief prefatory remarks. I think a few abiding themes should be borne in mind for an endeavor like this. I think it's vital to demystify technology. Today, there's a whole aura and a halo around technology that's built out that tends to put a perception divide and the creation of a have-not perception, which is true, but which is perceived in a much starker fashion because of the halo around technology. So the law campus is one forum where this can be addressed and dealt with, and I'll elaborate that a little more during the discussion. Second, I think it's important to become aware of how deep the intervention and usage of technology already is. We all tend to underplay how deeply pervasive technology is already making a mark in our lives. Look at the elderly around us, look at those in their 70s and the 80s, and the ease with which they use social media platforms or your WhatsApp groups, your uncles and aunties who have strong views to express. They're all doing it using technology. So we need to become aware of how easy it is actually and how pervasive it is. And being aware of it helps solve the rest of the divide. The third, I think, I just want to make two overarching points. Lawyers by nature are into coding. When we write a contract, we are writing a code. When we write draft law, we are writing a code. So there is an inherent connection between technology and its usage in law. And there's something to be tapped out there. And to then try and say that technology would be relevant only for some areas of law is an approach we should shun, because it's available, it's all pervasive. To my mind, text is data. And if orders of courts, show cause notices can all be text searchable and data can be scraped, we can come out with trends and we can come out with principles and attitudes of judges, attitudes of prosecutors. There's so much more technology can do across all spheres of law. So therefore, it shouldn't be restricted to fintech or a specific narrower zones of where the law has its play. Finally, I want to say that, look, as lawyers, we all tend to look at, say, automobiles, like those who like cars talk about cars, those who like computers talk about computers, those who like two-wheelers talk about the different types of two-wheelers. Usage of computers in the practice of law is the same. You don't need to be a car engine expert to be able to use the car. So if we use this philosophy in how we sort of ingrain the roots of technology and the usage of technology in curriculum, I think it would be a way to go about preparing lawyers for the next few decades. Thank you.
Thank you, Mr. Sundaresan. Finally, Ms. Bhandari, your comments?
Yeah, I have definitely not been in this field for as long as probably any of the panelists. And I'm probably one of those people, like Rahul said, who got into it much late, possibly just before this latest craze kicked in. But I do think that one thing that both Rahul and Somsekhar were saying, which I kind of also was going to say in my remarks, which is that I think one has to look at teaching technology, not just in terms of, oh, there has to be a separate course on, say, digital rights or technology, which I think there should be. I think it's important to have an introduction of these issues, just a very basic introduction of like kind of what are digital rights, what is like data protection, but also to think of it not just as a separate subject, but something that intersects with many different subjects. So there is an intersection, like when you're teaching constitutional law, I mean, what are digital rights litigation that we do in court is essentially applying like Article 19 principles to digital rights issues, proportionality doctrine, right? Like any litigation of technology rights or digital rights will involve like a necessary application of proportionality. So I think that's very important in terms of just understanding like constitutional law and digital rights will go together. criminal law and digital rights also go together. Like anyone who's working in the tech industry, you have to know what happens if the police shows up, or if there's a search warrant, or what happens if you get a section 91 notice. So I think what's important is to not just think of this as a separate subject and something that's completely unattainable, but something that intersects across different spheres, while at the same time, I think it is useful to teach it at least separately, and maybe not even as an elective, but or at least offer it in every law school, at the very least as an elective, where you give a basic introduction of what is privacy, what is technology, what are different aspects, just to give an introduction of some of the issues that people will be facing. I mean, you're going to have AI that's going to be there in medical, you have health tech, you have ed tech, like these are things that go across sectors. And I think when like the personal data protection bill comes, it will affect every company. It affects every business, it affects every company. So I think it's useful to have some basic introduction about those issues.
Thank you, Ms. Bhandari. Before I start with my specific questions directed at individual panelists, I want to point out to the audience that interestingly, all our panelists are convinced about the idea that definitely there is a gap and the gap needs to be plugged. So I don't see any scope for disagreement here on this panel. So through various questions, we will try and explore the various aspects of how this gap can be plugged in and what is the difficulty that we have to overcome. So I'll start with my questions to Mr. Mathan. Mr. Mathan, to give you a brief context to my questions, I was doing a quick Google search of the companies which are largest in terms of market capital. And if you take the top 10 companies in India, and if you take top 10 companies in the world, then I think barring one or two, almost all the companies are involved in the delivery of digital goods or digital services. This is basically a digital economy. Now, how do you see lawyers equipping themselves to respond to the legal challenges which come up in this digital economy?
Yeah, look, I mean, I think you're right. I think digital has overtaken probably every sphere in some way or the other. But I think there's a risk of overstating that, because look, we still need oil to run our cars. We still need to eat food. There's a whole physical underpinning to everything that we do. And I'd like to take that analogy to try and explore this a little further, because I don't think that everyone needs to become a Google. I don't think that all the lawyers need to become experts at coding. I'd mentioned this earlier. But I think what is inevitable is that a lawyer who doesn't understand technology is going to fast become redundant. And so we've got to bring back that concept that I think came out of the report itself, which is that technology context. I think we've got to, as law schools, focus on delivering that context. I think everyone has spoken about this in different ways, but I'm going to pick little bits from what everyone said. What Somesh said around contracts, right? I think essentially all of law is, Lawrence Lessig said this first. He said code. His first book was Code, and he tried to figure out a way by which we can get the principles, the definite principles of code into real life. And it's incredibly difficult, but it's possible to do in some small ways. Pramod and I are working on a contracting platform where actually a good part of the obligations are completed in code. And it's if you look at what blockchain is doing, increasingly you have smart contracts where the performance is completely delivered in code. And in relation to that performance, there are payments which are made or other subsequent performances that are done entirely in code. So in this environment, how does a lawyer function? Do we continue to impose belts and braces and continue to have those clauses in contracts that we've had for the last 100 years? Or do we look at the new reality and say, look, in this new framing, we don't need to do the contracts we did in the past? This is, I think, the change that we need to start bringing about in the way students think right from law school. So I think the first point that I'd like to make is that I don't really want us to stop teaching law. I think what Vrinda is saying is absolutely spot on, is that we need to teach people about privacy, but we don't really need to teach them how to build the tools of privacy. We are lawyers, and if we stop providing legal insights, then we are no longer useful. But the question I want to ask educators is that, can you really provide legal insights in the context of today's world if you don't provide those legal insights in a technology relevant context? And so we need to build that. How do we do that? One of the ways that we would do that is perhaps getting more, all of us are built to be multidisciplinary, but how are we being multidisciplinary? Are we actually exposing students to science, to technology? Are we getting people to come in from companies who are not the general counsel? Are we getting people to come in, to talk about autonomous vehicles? And we don't need to know how to build the autonomous vehicle, but we need to know the trolley problem in the context of autonomous vehicles. We need to know what are the ethics that one thinks about while programming a vehicle to protect the passenger over the pedestrian. We should be thinking about these sorts of things. And I'm a lot of my practice is very tech company driven. So even the examples I'm giving are very tech company driven, but we've got these issues in labor law. We've got these issues in tax. We've got these issues in the core of company law. And we need to actually present these issues in this sort of a context. When I went to law school, we studied legal history, economics and the law, sociology. Those are, in a sense, the old world intersections. We've got to find new intersections in terms of the way in which we bring this to the students. The second point that I have is that I think I will be surprised, but I don't think the students are the obstacles. As more people have said than not, the students, everyone who is probably listening to this, they're digital natives. We are the obstacles, the people who have been taught in the old school. And unfortunately, all teachers today are those who are perhaps not digital natives. And so maybe we've got to really invest in changing the pedagogy really at that level to really push teachers to find ways in which to provide this context, because I think students will lap it up. They see this all the time. And look, I mean, I would, I heard a comment just about, and maybe it was Somesh who said it, but there is this fear of technology, and there is this resistance. Lawyers tend to think, oh, this is tech, so I don't understand it and I can't ever understand it. And we've got to break it. I don't think the students believe that, because they really know how to get the most out of whatever it is, whatever the tech is that they're using, and we cannot let them have a fear of it. So if we are in a world where we're doing classes by Zoom, or we're exchanging documents, not printouts of projects at the end of the year, but something digital, I would say embrace it. I taught a course during the pandemic, completely through the pandemic. Vrinda very kindly participated in that course. And we used a tool called Kialo, which I found fabulously interesting. It's essentially a tool to develop arguments, and you have to state a proposition, and then below that you have to say, are you in favor or against the proposition? And below each subpoint, you have to say, are you in favor or against? It's the most beautiful way in which you can actually see the pros and cons of an issue. And we could never have done it if we weren't forced to do it in this entirely digital world that we're in. So if we are digital, let's embrace it. Let's actually use this as a turning point in legal education to say a good part of what we do is going to be in this hybrid online-offline kind of a framework. We will use tools like Kialo so that we can have asynchronous learning. People can, at their time, choose to create the arguments that they want to put up in their project. I would say, why don't we just completely rethink the project submission? Why don't we just do it on a Google Doc? collaboratively build this, this submission with interaction between a group of students and the professor, come up with, embrace digital, and find a way to integrate that deep into the teaching of the law. So these were some of the thoughts I had. I know Professor Nigam leaned on me to speak about privacy, but Vrinda went ahead and said what I was going to say, which is, privacy is a good example of the way in which technology is going to touch absolutely everything. I've always thought of privacy and the PDP bill, if it becomes law, when it becomes law, let me not say if, as a sub-constitutional law. There is no law other than the Constitution that will touch absolutely every area of practice. The RBI is going to have to come to terms with it. The SEBI is going to have to come to terms with it. CCI is going to have to come to terms with it. But no matter what regulation you've passed, once the PDP bill comes into force, you are going to need to retest those principles against the privacy principles, because that's just the only way that it will work. And if it's privacy now, we're going to have other areas of law which will have this sort of overarching reach very soon. I dare say things like ethics in AI could well be something like that will have a broad overarching reach. And it's really exciting to be someone coming into the practice of law now, because, old fogies such as us, just bear with me, old fogies such as us are, essentially, we've trained ourselves in the old school. You guys who are going to be the lawyers of the future have none of that baggage. So, just embrace it.
Thank you, Mr. Mathan. So if I may quickly take out 2 points from what you said. I know you made 2 points, but I'm going to take 2 things out of it. One, you said that the lawyers need to have context and they need to have the ability to connect the dots. That's how they can be well prepared to navigate through this digital world. Are there any additional points that any of the other panelists would like to make at this stage? The question was basically, how can lawyers equip themselves to navigate through the digital world and be useful when it comes to advising to businesses? Because businesses are also part of the digital economy, and most of them are delivering digital goods or services.
I would just add that I think that one thing that's just useful, like something I remember that used to always scare me, is like, how do you keep track of like what is happening in the world, right? Like so much is happening, and how do you even keep track of all the latest things? And I think one of the things that students have today, which is an advantage, which maybe we didn't have to that extent, is the number of newsletters, the number of podcasts, the number of social media, digital updates, which organizations like IFF put out, which, explainers. And I think there is just a different way of consuming content and understanding it based on what interests you. I mean, a lot of my updates of what I find interesting in the digital world, either come from Twitter, like just following people who I know are interesting, come from podcasts. A lot of podcasts, Rahul introduced me to one of them as well, Exponent. But lots of podcasts that talk about latest issues where you can hear experts discussing it, Rahul's own podcast. So I think there is just a really different way in which one can consume a lot of content if this is an area that interests you. In a way that I don't think necessarily was there when we were younger. And so, whether it's newsletters, whether it's articles, whether it's general, like I said, podcasts, I think that is something any student who's interested could consider in how to keep abreast with the latest changes in technology and the digital space.
Thank you, Ms. Bhandari. My next question is directed to Ms. Nagarajan, and this covers the other aspect of law and technology. The aspect which we just covered was basically how do lawyers equip themselves with the know-how to deal with the legal challenges which are thrown in this digital economy, digital world. But it seems that lawyering is not only about tackling issues which are coming out of technological advancements. Lawyers also have to adopt technology. They have to make technology a part of their practice. So in this context, I would like to request Ms. Nagarajan, if you could just give us a sort of bird's eye view of what should students expect when they talk about legal tech industry, when they hear this term?
Sure. So for me, after legal education, what would a student do, right? You have three opportunities. One, you go to law firms. Two is you can go to corporates. Three is now, of course, you have the big LPO industry. And four is now the emerging legal tech industry, which is a completely different industry from all of these three, which I've mentioned before. Now, I just would like to just share my screen over here, just to show you. So I hope everybody can see my screen. This over here now your legal market is $1,011 billion, right? This is where we are sitting after students, and this is the global legal market is $1,011 billion. So this is where we can get consumed as students. Now, in that market, a few things are happening. Technology is used in that market by firms, as I said, by corporates, by LPOs, whatever, for all of this, right? E-signature, contract management, document management. So you have all of these, IP management, e-discovery tools. All this is technology. What I'm showing you over here is what is being used by firms right now are all of this. So, you have all of these tools, and all these are technology tools. Now, who's building those tools? This is the legal tech industry. Now, when you look at the legal tech industry, you're talking about smart contracts, e-discovery, time and billing, security compliance, document management, transaction management, communication collaboration, document analysis, business intelligence, case management, document automation, legal research. All of this is the legal tech industry. So this is, this is the biggest part of the legal tech industry. And when I'm saying, you're seeing all of these companies which are just in the tech industry, right? So what I'm saying right now is, for you to be consumed in this, it is not just about, knowing about technology, which is one thing. And you have to be adept in it, because the previous slide which I showed you was exactly that. Because if you need to get into any of these, you have to know technology to be able to use these tools. So even when you're going for an interview to any of these companies, you have an edge. It becomes a matter of survival if you know any of these tools. And then you also have this huge market which is available to you, which is the legal tech market, where you can actually go and apply. For instance, I run legal tech companies, right? We hire lawyers. And when we hire lawyers, what do we look at? Not just coming from a law background, but if they do know something about software, something about certain tools, something about how they can think analytically. Of course, lawyers have a great analytical mind. I agree with Rahul when he said that, yes, it's akin to coding. You would be able to do much more. So please prepare yourself to do all of this, because the industry is so huge and it's expanding. If you look at the revenue of the legal tech industry right now, it is standing at, by 2025, we are at about $19 billion revenue. And by 2025, we're going to reach $25 billion, just the legal tech industry. So by equipping yourself, just think out of the box of just saying that, yes, that is also a place I can go to. Apart from law firms, corporates, LPOs, legal tech is also a place where you can go to. And also, if you are in one of these, industries, or even the, traditional law players or corporates or LPOs, you would need to know these tools to be able to survive. So I think basically what I'm telling students is, think out of the box. It's not just you do need to do law, and that really helps you. It's helped me a lot in what I'm able to do, but also that interplay of learning, and if it interests you as well. If you are traditionally focused, I think it's good to know technology to an extent so that you'll be able to use these tools. But the younger generation, being digital natives, it'll be easier for them. Millennials, it is easier for them to be able to use these tools with a few learnings here and there. So it's much easier for them. But if you are interested in the legal tech industry, it's much more. And also, I think students should not worry about artificial intelligence, because at no point can they replace lawyers. We run an AI company as well, and we need the lawyers to teach the machines. So it's not that if you have to equip yourself with artificial intelligence is going to take away your jobs. No, it's not that. Because without the legal acumen, without the lawyers, we cannot train the machines, and it's going to take you hundreds of years for actually machines to replace us. And I don't think we want to lose that humanness of anything if you just allow machines to take over everything. No, we don't require that. So we need humans to design these. We need humans to actually work with the machines to come up with designs, come up with concepts. Plus, with the legal tech industry, what we're talking about is the industry actually serves two people who are actually consuming the legal services. One is the industry itself, which are law professionals, and the other one are consumers. What are consumers demanding? We don't want to go to a lawyer all the time, right? We might want to because everything is being digital now. There's a huge digital transformation. So online, what are the services we can get online? Even for that, you need lawyers to design those services. So there's a lot of things which lawyers can play when designing these services for the consumers, for the client, for the industries as well. So students, I think it's great for you to think about that angle of yes, how can I be innovative? How can I join the legal revolution, and being equipped with technology to be able to do that, and to be able to provide better services both for the legal profession as well as to the consumers.
So I have a couple of quick follow-up questions to this. One, so I understand students need to develop the ability to think out of box. Also, they need to realize that they will be increasingly working with technology. But is there a different kind of mindset required when you are going to be a technology lawyer, in the sense that you're going to be using technology quite a lot? And second, how can law schools help students develop these abilities?
Yeah, so I think, one is being a technology lawyer, and the other one is exposing them to the legal tech industry. I think there are two different things, right? And if you're a technology lawyer, of course, educating them about, certain technological software practices and all of that, where, I think we have a lot of lawyers now who are in that space, and exposing them to industries like, you have health tech, you have legal tech. So if you are going to be specializing in that, then you need to be exposed to what is relevant over there, or what is the context over there, right? But in the legal tech industry, it is completely different. You need to actually think out of the box about how you're going to solve a problem, how you're going to, let's say for instance, a contract management tool or artificial intelligence. How can artificial intelligence be used in this process, right? Smart contracts, what are smart contracts? How can smart contracts be used over there? If it is your billing and all is quite rudimentary, but I'm talking more about predictive analysis and all of that. When you put yourself in the shoes of a consumer as well as the legal profession, and then you start thinking about how you can help them with technology, that's when you can really make a mark over there. The education you require over there, Aditya, is completely different. Like, for example, I'm again going to bring my example where I come from a legal background, but I actually learned, how do you develop a product? What is a software management cycle? How do you design? What is artificial intelligence now? But previously, I had to go through all of that, and I learned it through experience. I was in a company where I could learn all of that, right? And I self-learned. But I think if this can be introduced to students as a part of, people are interested in that, on, how do you design products? What is design? How do you think about innovation? Those things, if it can be introduced in the curriculum, then students can, opt for that as an elective, and they can go there and they can learn that, and then, see the interplay of how do you come up with a legal tech company.
Thank you. So I will actually not invite additional comments here. In the interest of time, I would like to move on to the next question, which is directed to Mr. Pramod Rao. And this is very specific to in-house counsels. I'm repeating myself when I say this is a digital economy. Most of the companies are offering digital goods or services, which mean, or they're trying to leverage technology in some way or the other, even if they're not offering digital goods or services. So there will be technology related issues which keep on coming up, which the legal departments have to handle. So is there any, is there an increasing expectation that the in-house counsels need to be tech savvy? If you could address this question.
It's a great question. I think I would put it in 2-3 buckets. I think one, that they have to be excellent lawyers is a starting point. I think that, we can't go away from the fact that they need to understand fundamentals of how to draw a contract, how to deal with dispute resolution, and so on. So I think that is a given at many levels. Tech savviness, I think, helps. I think it comes in with two levels of things which especially large enterprises do. I think one is that we have increasingly deployed a whole host of technology internally for us to connect both with the customers, but also with our in-house colleagues, colleagues at the business operations and so on. So being able to stay in touch, being able to provide that value, I think is important. But I think the second, and that is to build on what Chitu was showing, all of what you've seen, I think a huge adopters of law tech are really the enterprises. I think law firms tend to hesitate, or the budget might be too big for them to, expend on one particular solution. So I think enterprises end up adopting these technologies far more. And for that, indeed, we have our in-house team, which both looks at those technologies, helps shape them, but increasingly utilize and keep on giving user feedback. So I think that is what ends up shaping a host of these technologies too, and our expectations from them. Again, the adoption within the country has not been that big. I think, again, that is something that will happen over a period of time. And yet, to me, lawyers and law students who are not acquainted with them will increasingly find it more difficult to, sort of provide the basic service, as it were, to the enterprise itself. And therefore, it extends to our wider ambit. So not just the in-house counsels, but the counsels we work with, the external law firms that we work with. I think they all tend to then get connected onto these platforms one way or the other. And that's the importance of sort of staying in touch, I would say, with technology, or being tech savvy.
So I have a follow-up question to this. What are the qualifications, not in the terms of degrees, of course, but in terms of what should fresh recruits know when they're joining your team? And you may, as an in-house counsel, and you may contextualize it to banking and finance industry.
So I think the item which I emphasize always is that, the ABC principle: always be curious, always be, willing to sort of learn what the business is about. And I think from that, you derive what the technology is actually seeking to do. What are we seeking to deliver to the customer, and so on. And that's when you recognize both the pitfalls, you recognize what can go wrong, and you sort of plan for that. I think on an earlier question you were asking, Rahul, which I wanted to answer, but let me do it here, which is that many times it is just providing perspectives to the business folks or to our operations colleagues that opens a host of other elements that we can sort of do, right? If you think about what has happened in the pandemic world, one of the questions we posed was that what are we doing about deceased claims? What are we doing about account holders who might have perished in the pandemic? And suddenly it prompted the ops and so on to start re-looking at what were we actually processing these survivors' claims with. Now, some of it might be technology, but a lot of it is equally these lenses that I think we as lawyers bring to the table. And which is why I would sort of say that be alive to what's going on in the society, be alive to bringing it in. And more often than not, that starts shaping a host of behavior as well, and hopefully good behavior at that.
Thank you. I've caught on to some words which have been spoken so far while answering my questions, and I want to throw a question to everyone. So the words I've caught on to is out of box context. The young lawyer should have a context. They should have a perspective. They should be able to connect the dots, which actually probably I only said. The reason why I'm mentioning these is, so this is anecdotal, and I've been told that in earlier days, when the traditional practice was what most of the lawyers did, the seniors used to advise that, you should read literature, you should watch drama, you should appreciate art. It will give you a perspective. You will be able to think out of the box. No one has ever told me, so I don't know if it is true. But when you say you should, get courses on design thinking, you should, just try and understand technology, how different technologies are used. You should listen to different blogs and podcasts to make yourselves aware. Is it basically the same advice which will be working today as well? But of course, the things which we need to appreciate have changed. So it's a very vague question and a little loose-ended. I would like to know your inputs on this. Anyone can go
If
first.
I may jump in, Aditya, I think that same advice continues to all the young law students. And in fact, it gets overemphasized and more underlined with the impact of technology on society. The need to read history, the need to read behavioral economics, simple things about psychology and human conduct actually has gone up thanks to the impact of technology on society. If you read through some of the biases in human decision making, most of the experiments that Daniel Kahneman did centered around errors judges would make in terms of believing they're rational, but making decisions which could empirically be shown to be irrational. Something as simple as introducing a chocolate in the menu at lunch on certain dates. After lunch, the rate at which bail would be granted would go up, for example. But there are other effects of technology, the availability bias, the fact that you have thought about a point because you looked it up thanks to technology, does not make that point a very important point. Because you thought of the point, you tend to think it's the best point possible. So for lawyers to overcome these biases is very important. And when technology throws so much information at you, there's so much noise also that comes with it. So the ability to think out of the echo chamber, the ability to break through the noise and look at an issue needs to be honed for lawyers. So therefore, all of what you said about the elders asking to read about economics and history and literature, that is further underlined. And even there, technology makes it easier to read literature. It makes it easier to read about economics. You don't have to be a member of a library which is privileged and somebody has to introduce you. So much is available online today. So therefore, all of that advice still holds good.
Right. And
I wonder if that answers what your
No, I would
was.
equally, supplement what Som is saying and what Vrinda also hinted at. I think just being a sponge, being just absorbing everything which is around you and not necessarily connected to law. I think, having an expansive view would be a far better sort of approach to life. Rahul, for instance, on his Twitter handle actually posts the 50 books that he read last year. I remember following that for quite some time, and it expanded my library as well and perspective. But I'm just saying those are what you need to do. You need to develop those, and I think connecting the dots becomes easier when you have read, when you have heard, when you have seen. And I think today that amount of information which is available is historically never been seen earlier, right? So whether it is podcasts and audiobooks, or whether it is YouTube videos which teach you various things, or indeed books, which is my preferred way of learning. But genuinely, I would think that is really astounding, and people who fail to capitalize on that are missing out on a huge opportunity.
And also, like, sorry, just
No,
one line. I also think it's important to do this wide variety of reading to understand the impact of technology on society and on like different social classes. Like often, I mean, I think, we saw this kind of in Aadhaar, that the impact, say, on a certain class of people was disproportionately higher because, some parts of the technology don't necessarily work. And so I think it's also important to just see it to understand who is this technology going to be used? What are its implications? In which case will the biases also creep in? So I think even for that, you need an understanding of how society works. I mean, there's so much writing now that comes out in terms of facial recognition that the bias that is encoded within the algorithms itself is something that is worth being cognizant about. So I think even for those reasons, it's very important to read widely and to understand the society in which the technology is being deployed.
Okay, thank you. Thank you so much for your inputs. And thank you for entertaining this question. Next question, I actually have not for one, but two panelists. The reason why I've clubbed the two panelists together in this case, because both of you practice before court. And I just wanted to know that since whenever and I'm talking about Mr. Sundaresan and Ms. Bhandari, that whenever we talk about law and technology, we always think of big tech. Even earlier, when I was saying that, the largest companies by market capitalization are probably digital companies, Google, Facebook. In India, you think of TCS, Wipro, etc. So why should someone who's practicing in, let's say, a district court, we really be interested in updating himself or herself that I need to know about technology? How is it going to affect me in my daily matters of property law or contract law or criminal law for that matter? Where is the need for the rest of the lawyers to update themselves if they are not catering to the, what I may say, as a more categorical corporate practice? Mr. Sundaresan?
Brinda, you want to go first? Or?
Sure, yeah. I think I think the way I would look at it is just to say that, okay, you obviously don't maybe necessarily need it, but I think the way it would come, for instance, in a traditional criminal law practice is you have the police sending requests to all companies, right? Or to many companies for documents, especially if you're doing anything that's, for documents under section 91 of the CRPC. And so, what are those kinds of documents that the police can ask for? How do you kind of respond to that? So, you then have those issues when you're also interacting directly with the police, when you have to understand what happens. I mean, I think a great intersection of criminal law and technology is this whole area of law that no one is clear about. If you're arrested, does the police have a right to take your phone? Does what is the balance of self-incrimination? Do you give your passwords to them? How does it actually work in practice versus, what the law says and what the kind of compulsions in terms of bail are, right? Because I think bail law says, oh, you have to cooperate with the accused, or with the police, with the investigation. I also have a right against self-incrimination. So I can say, I'm not going to give you my passwords because that violates my right against self-incrimination. But then in bail tomorrow, the prosecution will argue that they're actually not cooperating. So please reject bail. So I think the way it comes into interface is just understanding how constitutional principles will apply in criminal law in a digital context. When you're talking about phone, when you're talking about data that's stored, for instance, on our computers, like good data hygiene practices, right? So everyone says, oh, WhatsApp is encrypted. But a lot of people, for instance, don't necessarily realize that the automatic WhatsApp chat backup that many people mindlessly kind of without realizing say, yes, please back up all my chats, that's not encrypted on Google Drive. So your entire kind of WhatsApp chat backup is completely unencrypted. So there's no point of having security on your phone if your backup drives are not encrypted as well. So just like, I think understanding how technology works, what are good digital security practices are things that are important, even from a security perspective, if not just a technology perspective. So yeah, that's just, I guess, to give one example on like criminal law and tech law, which I think are important. And then the second is, I think as probably everyone mentioned, that understanding what is data, what is private data. If you're a company, or even if you're a property, if you work in property law, what is the data that's being collected? You often will collect financial data as well. What are the rights that your customers might have? I think one significant shift that has happened since Puttaswamy is the Indian user is more aware. They know that there is this thing called privacy and I have some rights. And once they will have a statutory legal framework under the PDP bill, they may be much more willing to exercise these rights. So you will have to see companies waking up to learn and lawyers waking up to learn what are the implications of the data that they're collecting.
Mr. Sundaresan?
So I'll keep this at a far simpler practical level, if you will permit that, from a district practitioner's point of view. Let's remember that justice delivery at the front line is in the districts. The rule of law and the effect on society is most felt only when rights are enforced effectively at the district level. So when technology really can add value at that level, a district lawyer has to be on the curve and be able to handle it. Increasing number of states, for example, have land records in a digitized format. If you don't have the skill set to do a search when the data is available to you, to check land titles, what are you as a lawyer? What value do you add to your clients? Clients are smart. Remember Lala Sukram was a technology minister who introduced cellular technology into India and in the Narasimha Rao minority government. It was very, very popular politically. He had a lot of controversy about bribery in telecom technology, but so popular that he switched parties. He was wooed by multiple parties. And why was he popular? Apple growers in Himachal were able to use technology to know the price at which apples are sold in Bombay. So the middleman could not make money out of them beyond a certain margin. And he was very popular. He would always get elected. So the effect technology can have on the grassroots is something that is very, very discernible even in justice delivery. And if a district lawyer is equipped with the ability to handle technology, when the pandemic is behind us, if and when it's behind us and technology is here to stay, imagine it, he doesn't need a Bombay lawyer or a Delhi lawyer or a Calcutta lawyer to appear for him in the High Court. He's better equipped to handle the case for his client sitting in the district. If a decent e-Seva Kendra that works with reasonable broadband can be made available, he would be fully equipped to handle it, cutting out the middleman, which is lawyers like us from the metropolitan cities. It's an enormous, powerful tool that can empower the legal fraternity across the country. And therefore, I think it's very, very important to remove the halo and to say that this is a very simple tool that can be used by anybody to participate in justice delivery and be that service provider for the client. So I think it's far more important at the district level than at the metropolitan level.
So my follow-up question would be then how can we train students in law schools to be able to deliver these responsibilities that you just spoke of, as you said, that, district court is the most important when it comes to rule of law, right? So what can we do in the legal curriculum? What can we do in the pedagogy, if there are any suggestions on your part?
See, I think it'll be important for law schools to have laboratory experiments in their libraries. For example, are you able to scrape every order passed in a certain district or every order passed by a certain regulator, create a database of it and build trends? Suppose you had programs and projects for students to come up with saying, what are the top 3 issues that have emerged in land disputes in an area around an SEZ where land is being acquired? Which were the questions of law that emerged in the courts of the first instance? And students do that research using that data. Now, of course, not everything is available in text searchable form. There has to be work at it. The judiciary is waiting to support such endeavors. And therefore, if law schools can play that bridge role and enable such projects, students will understand what use they can put technology to without having to be practitioners in the field of financial services or information technology or data privacy. The use in criminal law Vrinda has spoken about. I mean, I dread to think of AI taking over the role of magistrates, because if data capture is wrong, the biases will get institutionalized and embodied in the coding of the AI. So there is going to be a transition phase that needs to be thought through for these. But on the civil side, is it possible for law schools to develop projects or develop programs where in a non-high-tech sector of law, students are encouraged to deploy technology and make use of technology to study trends, study developments, or look at the march of the law. Suppose you want to say, how has the law evolved over time? With something as simple as land acquisition or something as different as domestic violence. What are the annual reports of various authorities under POCSO law saying about child sexual offenses? And what has been the trend? Use technology to develop that. And that's how you break that mindset to say, this is something that can be used across the board. And law students will start seeing how they can put it to use. And you'll be surprised how much value add students may bring back. I also think increasingly the law course has become a filter like the MBA. And the number of law students after graduating from law school becoming startup entrepreneurs. We have one on the panel as well, I believe. So that's also going up. So it will build into that ecosystem. These sort of experiments in law school will feed into the wider ecosystem of legal services support. And that's a service you would do. So as a practical measure, I think these are some steps to think about on how to use technology in campus to make students more conversant with the use of it.
Thank you. Thank you so much.
Aditya, may I interject very briefly? Largely because you said that this panel doesn't disagree, so I want to disagree. And I want to leave this panel on a slightly unsettled note. This felt all very convivial, and I want to leave students with a thought. Both Chitu, I think Som and Vrinda said that AI will never replace lawyers. And that we should be very scared of AI being magistrates. That the biases that humans have will get coded into the machine. I have learned in 25 years of being a technology lawyer to never say never. The first thing that you learn is everything that you thought was impossible will become possible before you know it. I think the acknowledgement that there is bias that can be built into AI has already taught us to find ways to remove the bias. So if you as law students think that your job is not at risk, you will be like the newspaper industry that thought nothing would happen, or like the music industry that thought nothing would happen. If you are a lawyer who wants to be completely understanding the impact of technology and law, you need to continuously be the thing that disrupts the profession. Otherwise, something else, something like what Chitu is building or what others are building, will disrupt the profession. So I would just say, completely, there is nothing that is off the table. If you want to see the impact of technology on law, actually go all the way to the basics, because at some point in time, someone will build an AI with even less biases than the AI has today. And just to pick up on what Som was saying, the reason why we used AI to make decisions was because humans are so flawed at decision making. So we thought perhaps a machine would be better. And now we find that the machine has borrowed some of our biases, but we will find a way to clean it up. And then what is this profession of law that we're spending 5 years studying and 25 years practicing? Is it going to be completely shaken up, completely different in 10 or 15 years? Sorry to leave you so completely unmoored from reality, but let's just keep in mind that could well happen.
Just a quick point, Aditya. Just a quick point to say.
I think I will have to interject here. I have been
never said never.
Aditya, you're past the deadline. You need to close the discussion. We have the second panel waiting. But thank you so much for the comments that you gave. And towards the end, if left to me, I don't want to end this discussion right now. But I hope that everyone understands that why I will have to do so. Thank you once again. I will leave people with 4 words, which I'm going to repeat. I mentioned them earlier, which came out of this discussion, that lawyers, if they want to deal with the challenges which will be thrown in the digital world, they need to train themselves to have a context, to have a perspective. They should be able to connect the dots and think out of the box. Thank you, everyone. And may I please request Mehika to take over?
Right, sir.
Thank you.
Thank you to all the panelists. That was indeed a very interesting discussion and indeed a very engaging discussion. May I now have the honor to introduce our panelists for the second panel discussion called Technology and Legal Policy. The academia is increasingly gaining cognizance of the need for law students to be equipped with the relevant knowledge and skill sets required to function in the new digital world. Universities are making efforts to prepare law students to face the legal challenges being posed by advancements in technology. Relevance of understanding technology is important not only for the commercial lawyers, but also those dealing with issues related to rights and policy. Technology is a part of our lives, and it impacts us not only individually, but also as a part of our society. Our second panel for the day comprises of law academics and policy experts who shall be discussing the ways to bring about transformation in the legal curriculum to prepare law students to tackle the challenges of the new digital world. Joining us for the discussion, we have Professor Soledad Atienza, Dean, IE Law School, Professor Roger Brownsword, Professor of Law at King's College London, Dr. Vikas Kathuria, Fellow, Observer Research Foundation, Professor Sudhir Krishnaswamy, Vice Chancellor, NLSIU, and Mr. Amlan Mohanty, Public Policy Council, Google India. The discussion will be moderated by Mr. Anubhav Rajshekhar, Assistant Professor of Law, BML Munjal University. Over to you, Professor Shekhar.
Thank you so much, Mehika. A very good morning, everyone. My name is Anubhav and I'm Assistant Professor of Law at the BML Munjal University. I shall be the moderator for this panel. As you're aware, the panel comprises of eminent personalities from the field of legal academia and policy. It will explore the ways in which legal curriculum may be redesigned in a digital world, providing insights from the academic and policy perspective. Our primary discussion point for this panel would be that how do we redesign legal education to include contemporary policy discussions on law in the digital world. Now, Aditya in the previous panel had said that he does not preempt any disagreements, but I'm not going to go that far and say that there will be no disagreements. We'll perhaps find that out during the course of the discussion. But as a moderator, I would like to just inform everyone, our panelists, as well as our audience on the flow of event and how we are going to do this. What we are going to do is that we'll have 2 minutes of introductory remarks from each of our panelists. Once the introductory remarks have concluded, after that, of course, we have in the members of, in our audience, we have members from all across the world, who want to hear different panelists, and they're here for them as well as this in totality. But considering that, and in the interest of time, I would request each panelist to sort of restrict or conclude their answers within the span of about 5 minutes when the follow-up questions happen, and following which all panelists would have an opportunity to respond to the comments made by the specific panelist in about a minute or so. After which, if time permits, we will have a Q&A session in the last 10 minutes or so, which the caveat being if time permits, and then we'll conclude this discussion. So that is the flow of the event. Let's just start with the introductory remarks, and I'm just going in the sequence of what I see on my screen. May I request Professor Brownsword to commence with his introductory remarks.
Well, yeah, thanks very much indeed, and thanks very much to everyone. I've rarely been in a conference where I've agreed with so many of these remarks. I must congratulate you on being in the vanguard of thinking about law and technology. Wonderful. So I entered law school in London in 1965, and so my first-hand experience of law schools goes right back to the 1960s. And during that time, there have been some huge changes. So you compare the law school that I knew in 1965 with the law school in 2021, it's a very different place. And the first thing is, it's very different in the way law students study. When I was an undergraduate, my main problem at the London School of Economics was finding the law reports, finding the law reviews that I was required to be reading, because they only had one copy, generally speaking, of each of these items, and there were too many students chasing too few books or reports. There were also too few seats in the law library. So there was a shortage of resources, of books, a shortage of seats, and it was technology that was going to come to the rescue, but not for some years later. And the first rescue was with the photocopying machine, because that relieved huge pressure on the books. Even if they only had one copy, students could make many copies of the book. So the library became a kind of place for industrial copying. There were negative effects, but it was largely positive. But of course, with the digitization of legal materials, there was a massive leap forward, and the availability of these materials 24/7 through devices which students were carrying meant that the problems were solved, not just the book problem, but the seating problem too. Students didn't need to be in the law library any more than they actually needed to be like disputants need to be in courts. But it's interesting that one of the thoughts is that we should be going forward by returning students to physical spaces, which become kind of labs where they work with technicians. Very interesting sort of another direction. But the first thing is that law schools have been transformed by the way students study. Secondly, they've been transformed by the way we deliver our courses, partly, as I said earlier on, because of the acceleration brought about by the pandemic, but the way we teach, the way we deliver has been transformed. The one thing that has not been transformed, the one thing where there's been virtually no change at all, is with the curriculum, what we teach. So the way students study, the way we deliver our teaching is all changed, transformation, unrecognizable, but what we teach still looks pretty similar in many respects to what we were teaching back in 1965. And what we were teaching then was trapped in what people here are thinking about as a box. We think within a box, as I'll explain later on, I call law 1.0. We're trapped in that box. What we have to do is get out of that box, because without that, we don't begin to explore all these important questions that we've heard today that are on the agenda. So that's what we need to do. And the curriculum, debate about the curriculum is why we have to tackle that. And I'm looking forward to this panel and its discussion.
Thank you so much, Professor Brownswell. May I now request Professor Krishnaswamy to go forward with his introductory remarks.
Thanks, Anubhav. Good afternoon, everyone. And may I thank the BML Munjal University for inviting us to be here. I think it was Vice Chancellor Dr. Manoj Arora and the Dean Preetham who have had put this together, but it was Nigam who invited me. So thank all of you for bringing us here today and to discuss what is a topic that is both old and new. Old in the sense that people have been talking about the effects of technology on law for some time and predicting the demise of lawyers and law schools and other such attractively titled books. None of that has happened, though we always work with the sense of an imminent sense of a crisis around the corner. Rahul Mathan kind of closed the last panel suggesting as much for practitioners. And it's useful for us to reflect as we begin this conversation, what this might mean for the law school and for legal education. And I'm going to keep my reflections. I think Anubhav instructed us to take somewhere between 2 or 3 minutes. So let me use my remaining 2 minutes to share what some initial thoughts on this issue, at least at the National Law School in Bangalore are. The first is that most law and technology work has always been brought into the curriculum as a law and field, right? So there is law and in some meaningful way, there's and technology, the sort of conjunctive and is supposed to add some dimension to law. And we've come to understand that, that technology infiltrates into legal educational practice and legal practice itself, professional practice. And so students must be made aware of law, of technology in this sense. And I think this kind of conjunctive mode is past us. I think what, and I'm going to just rely on an unlikely source that I would never rely on in an article, a peer-reviewed article anywhere, and that's Thomas Friedman writes an interesting op-ed in the New York Times, where he suggests that, you know, the SAT must be reinvented to teach only, to really test two kinds of code. And he suggests that the two kinds of code are first legal code or constitutional code, as he's concerned about, and the second is computer code. And he then, you know, as these op-eds go across 1,500 words, makes some argument about why these two kinds of code are centrally important for a democratic society. And I'm going to riff on that article. None of what he says is where I'm going. I'm going to suggest that at least since Lessig taught us in the early 1990s that law is fungible in code, we must begin to take what that insight means seriously. And here I'm going to suggest that rule-based dispute resolution bears such, in the social world, which is the function of law, bears so much resemblance to you know, formal algorithmic decision making in computer devices, that we must start to take and work that analogy seriously. What is a curricular, and I know I have now about 45 seconds, what is the curricular upshot of this? I think the curricular upshot of this is that we must teach data and computation as a core course. We must reframe the way we think about legal rulemaking algorithmically. And students must have that analytical frame from the very start. I mean, I would say this is first year course. You must be able to do computational thinking. And by this, I don't mean some kind of, you know, you must know how to do search functions on Microsoft well or something like that, or Google for that matter. That's not what I mean. I mean actually learning computation 101. And I think this is fundamental. But looking ahead, I think that the three main ideas that we can learn from this broader field of especially computer software and technology it's to my mind first that search has fundamentally changed, as Roger rightly said, and Roger, I'm probably the last generation of students who went to that physical library first. You know, I graduated in '98, and I think students who came after me went to digital sources first, and books were an adjunct to their search. But I think we've gone far beyond that. I think search is so powerful in our field that it almost has the capacity to replace the physical search in a substantive way. So learning, retooling search is a very important legal skill. Anubhav, I know I have to let you go. Two quick things. Document creation has reached a level where I think that great emphasis that we place on legal document creation is going to be fundamentally disrupted, if not already. And third, that we must think about the way code is developed in a kind of with large numbers of contributors in the crowd, using agile models to think about the way law and policy is written. I think all of these three are fundamentally disruptive to the way law is taught and the way law is practiced, and we should be thinking about it in useful ways. Back to you, Anubhav.
Thank you. Those are some really interesting points, and I believe, you know, time is relative. It runs faster if you're the moderator. and slower if you are a panelist. So thank you for that. And let me now just move on to my other panelists. And may I request first Mr. Mohanty to go, then Professor Atienza, and lastly we'll have Dr. Kathuria. Thank you. We can't. Is it only me who can't hear? Or? Okay. Meanwhile, Professor Atienza, can you just proceed?
Sorry,
with your...
Can you hear me now, Anubhav?
Yes, I can. Please proceed. Please proceed.
I'm so sorry. I'm so sorry. I just had to refresh my tab. So yes, I was just saying thank you for inviting me, BML Munjal University, Professor Nigam. Real pleasure to be here. You know, I mean, having heard the panelists before me, I thought I'd just come at this from a slightly different perspective. I'm going to look at this from three sides, right? One, as a law student who from the first year of law school knew he wanted to work on law and technology. So that's really, I think, something that's really been driving my thinking around this. The second is having recently taught a course at NLS on law, tech, and policy. And third, now having practiced law and tech, both from the legal side, but also now in-house as a company that's at the cutting edge of technology. So I thought that's the three kind of perspectives that I'd like to add to this discussion. And maybe in my opening remarks, just touch on 4 points. The first is just to comment a little bit about, you know, the fundamental question of why technology is important to law, to the practice, to students. And then I just like to briefly leave you with the thought that actually all questions of law right now are questions of technology. Just given how pervasive technology is, right? There isn't a sector now that isn't touched by technology, whether it's healthcare or agriculture or education or entertainment. So I know from having spoken to my practitioner legal friends that they all need to understand technology. And we should get into what those questions of technology are at a fundamental level. I have the privilege of working with, you know, research scientists and engineers and technologists at Google who are at the cutting edge of this, and they have a very simplistic way of explaining some of these things. And I think we need to bring that to law schools. The second is to comment a little bit about the political economy that we're operating in right now, right? And I think it's really important for all of us to realize, even as users, we're operating in an attention economy. Time and attention are scarce resources. And it's important for both students and practitioners and teachers to think about this, right? What does it mean to teach a course now when you're competing with smartphones and laptops and really the power of the internet? You cannot command the kind of attention or expect that amount of attention that you did even, you know, a decade ago. So keep in mind, you're competing with YouTube, you're competing with Wikipedia. You really have to make your course interesting, right? And that was my learning, at least, right? If every lesson is not invoking some curiosity or some passion that the students have, you're not going to command their attention. So I think that's the second, observation that I've had from having taught a course. The third, I think, high-level comment I have is about how, and I think the previous panel was really interesting in terms of what technology can do for the legal practice. I actually think there is a role for technology in both legal practice, legal academia, teaching. And I think what we really need to do, again, is understand how technology works and where can it actually help and facilitate learning and instruction, right? Rather than worry about or be anxious about how it might, you know, result in job displacement. So, you know, there are fundamental concepts in technology like AI and ML tools that do things like classification, prediction, you know, generating text, understanding, you know, natural language. How can we leverage some of these tools to help facilitate instruction and learning, right? So maybe we should get into some examples later on. But I think there are tools in the market and there are tools that are going to come out that we really need to, I think, adapt through, you know, investments in infrastructure that we should, you know, talk about. And the last thing I'll say is about pedagogies, right? And this is, I think, something that more recently I have started to observe and try to adapt into my own thinking, which is that we need to be interdisciplinary. Law cannot operate in a vacuum. And I know this having made that transition from law to public policy, especially, where you are not operating in purely a legal domain. You know, of course, frameworks from the legal from the legal discipline are helpful, just things like, framework for analysis like IRAC, but you have to draw from things like economics, you have to draw from sociology. We talk a lot about how the impact of technology on society can only be understood by an anthropologist or a sociologist. So we really need to think about a cross-disciplinary approach to legal education. So I can get into more details, but thank you.
Thank you so much. Very quickly, Professor Atienza and Dr. Kathuria, may I request you to make your introductory remarks?
Good morning. It is a pleasure to participate in this panel today. And as a brief introduction, I will just mention what I believe are the greatest trends in both in the legal industry and in legal education today. The first one for me is globalization of legal services provision and internationalization of legal education. And the second one is the use of technology, again, both in the legal industry and in legal education. But what I believe is challenging, what I believe are the biggest limitations to a more international and to a deeper technological legal education, and I think this is what's interesting here, is the regulation. And I consider the regulation in two different aspects. So the regulation to access the legal profession, which is highly locally regulated around the world, and the academic regulation, so the way law schools, universities, and law programs are regulated. I think these are the bigger limitations to a more international and to a greater use of technology in legal education. And with this, I end my introductory remarks.
Thank you so much, Professor. And lastly, may I request Dr. Kathuria? Thank you.
Hi, thank you, Anubhav, and thanks for having me here. Good afternoon, everyone. So I come from the competition law background. And what I feel that in my field, understanding technology is extremely important. And it's not just a new phenomenon. So far, what we have heard in the previous panel and to a certain extent in this panel is the idea of technology as a platform upon which we base law. But there is one more way in which law interacts with technology. When we see law as a means to justice, it becomes context dependent. And when we are talking about Industry 4.0, it has become extremely important for lawyers, legal academics to understand the technology. But as I said, that it's not a new phenomenon, at least for IP and competition lawyers. Well, let's go back to 1980s, like the Nintendo versus Atari case, when Atari made interoperability difficult, primarily through contractual means. One needed to understand how these game consoles worked at that point of time. Now, just fast forward to late 1990s, the fabled Microsoft case. And that was the case that made it very much clear that if we need to understand, approach justice in these markets, we need to have a very good understanding of how operating system works, what was time, even though window media player was coming for free, browser was coming for free, what was the theory of harm? So these were the early cases. But now, since the technology has become far more complicated, even the law needs to catch up. When I was at the Max Planck Institute, we were sitting with the computer scientists, we were sitting with the computer engineers to understand that how the AI black box works in order to make sure that granting intellectual property rights do not they conform to the previous set notions of IP. We also had to deal with the Facebook cases where APIs, application programming interfaces, were used to harvest data on the third-party website. So we actually had to talk to them to understand what APIs are, how they actually work. Now, and there are multiple cases against Google in the EU and also in India. So you need to understand, what is the Android platform, what is forking, and how algorithms work, etc. So it's become a necessity all the more for competition in IP laws. But what's the new phenomenon? I see that the new phenomenon in this case is that not even IP and competition law people, but also the civil rights people and the constitutional law academics, they also need to understand technology a bit better. Say, for example, after the Putasamy judgment, of course, it is, right to privacy is the fundamental right. Now, say, for example, I come up with a privacy enhancing technology, say for example, personal information management system. Now that's a technology that in principle strengthens privacy, but how would it actually make sure that the law is respected? So even the constitutional law, people need to understand technology in the way that was not happening maybe in the past. So I would say that what students should be doing, the students, regardless of the stream that they are focusing on, they should be seeing it as a basic necessity that no matter what they would be doing in the future, they will have to deal with the technology.
Sure.
These would be my primary remarks.
Thank you so much. I believe we're just running a little late in the sense that almost everybody took about 3.5 minutes, barring, of course, exceptions. But let's just proceed with our with the questions that we have for individual panelists. Now I would request you to take about 4 to 5 minutes, considering that we have over short time, and therefore I'll request you to definitely wrap it up by the 5th minute, that we can have about 30 seconds of response from any panelist who wants to respond to any comments that have been made by the speaker. Let me just start with Professor Atienza. And my question for you, Professor Atienza, is that I mean, today we had the report, and we have the audience has already seen the major findings of the report, which were discussed by Mr. Lucas and Professor Nugehali from BMU. So we know about what our findings from India are. So what I know is that you have worked on a project for development of a blueprint outlining key trends and challenges emerging in legal education. May I request you to kindly share in brief your findings with regards to challenges as well as opportunities in legal education that find form due to these dynamic changes in the technology?
Sure. Just to confirm, I have 5 minutes now?
That's right. Yes.
Okay. Thank you. Yes, if I may, I will share with you my screen. You can see my screen now?
Yes, yes, you can.
Yes. So, oops, sorry, let me, no. What I'm going to share with you is the conclusions to the report that you are mentioning, which is a research project that I have been working on for the International Bar Association during the past year, studying what are the biggest trends and challenges, as well as opportunities for legal education around the world. And as I mentioned, out of this report, we have gathered 4 main trends. So globalization of legal education, the use of technology in legal education, skills for the legal profession, and regulation of the legal profession, as well as regulation of academic regulation. These are what generally most law schools and law schools representative around the world, after having studied over 500 law schools, consider are the most relevant trends. Now, the challenges, as I briefly mentioned, are the regulation to access the legal profession, as well as the resources, and the regulation to the academic regulation. This is what is limiting many universities and law schools to offer a more international legal education and to use to a greater use of technology. I will focus on the rather than on the globalization. I will focus on the technology. So what we have learned through this report is that there's different levels by which a law school can use technology. What we consider is a medium level is the use of technology as a teaching tool. This has, of course, grown extremely fast during the past year. So in this sense, I would say that the pandemic has been positive in order to push the legal academic community, law students, staff, and law faculty to a greater use of technology as a teaching tool. Now, I am optimistic about this because I think many of what we have learned is going to stay in this sense. So the use of technology as a tool. Before the pandemic, many jurisdictions did not consider official the programs that were run partly or fully online and did not grant access to the legal profession to those programs that were taught online. Now, again, I'm optimistic here because this has changed over the past year and it is something that it may remain. So there's going to be more flexibility for law schools to teach online. We have proved, and I'm sure all of us have had to make a big effort during the past year, we have proved that it works. Students have proved that they can commit to it and that they can learn also through the online programs. Now, what we consider in this report that is a high level of use of technology in law schools is not using the technology as a tool to teach, but it is to include technology as a content in the program. And again, here there's different levels. First level would be to use to introduce courses in introduction to technology or to programming or to computing. A second level would be to introduce courses that teach about technology for the provision of legal services. So how do lawyers and judges use technology in order to offer better legal services? And the last one, which I consider the more complex and the most sophisticated one, as well as the most interesting, is the regulation of technology. So regulation of artificial intelligence, anything about privacy, smart contracts. This is what I think, again, is the most interesting. And these are the three levels of courses. So basic technology, technology for legal services, and law of technology that law schools are implementing. But I have to say that it is, through our, as a conclusion of our analysis, it is a very small number of law schools that are doing this around the world. So there is an intention to grow in this sense. This is a trend, but as I said, it is a very limited number of law schools that are currently doing this. And just to finalize and to briefly gather the conclusions of our report is that the trends and challenges for current legal education globally are internationalization, the use of technology, skills for a legal profession, regulation of legal education, diversity as a community, as a law school community, and other challenges that have arisen since the pandemic. And I will now stop to share the screen, and I'm happy to take any questions now or at the end of the panel.
Thank you so much, Professor Atienza. You took exactly 5 minutes, so thank you so much. And now, I think those are some very interesting remarks and findings regarding the levels at which technology and law interact. Now, may I just briefly request a very short response, if at all, from any of the panelists. Please go ahead. The floor is open.
May I?
Sure, please go ahead.
Just a quick question about whether your study reflected on the effectiveness of online teaching and whether you have any data on that. It would be interesting because all of us have had to do it in some way or the other, and it'd be useful to learn from other experience. And my second question was that, did you find the growth of dual degrees or twinning programs in the legal education world in this period, or do you find that that is yet to take place?
So concerning the effectiveness or the experience in online teaching, I have to say that we ended the report as the pandemic was starting. So the literature that we looked at was really beginning. So we don't have that many data on that. The data that we have is that those jurisdictions that before the pandemic did not allow or did not grant official credits to online programs had to do it during the pandemic. So that's what I think is relevant here. Also, that all of those institutions that were not using online teaching at all had to not only introduce, but had to go fully online. And the result was that they all did it. So I do not know of any law school that had to shut down and not teach any classes. Everybody was teaching the classes online, which again, I think is a huge success for many universities. And considering to your question on dual degrees, yes, we do have data, and I can later point to you where this is, on a growing number of multidisciplinary programs. So multidisciplinarity is one of the trends, as far as we have learned in this report, and it goes beyond the most traditional ones are business administration and law, or international relations and law. But there's new trends also in multidisciplinarity, such as politics, law, and economics is a growing one, but also artificial intelligence, law, technology, and law, programming, and law. And this is also, we believe, a growing trend, and it is in the area of more multidisciplinary law programs.
Thank you, Professor Atienza. Now let me move to Dr. Kathuria. Dr. Kathuria, my question for you is that, we've observed that there's some hesitation in law graduates in taking up tech policy work. And this hesitancy could be attributed to the fact that there is a notion that having a deep understanding of tech is important before you become a technology lawyer or a policy specialist. What is the level at which a law professional or a law student should appreciate technology? Should they understand technology at a granular level, or is it sufficient to have a broad-based understanding of the framework in which law interacts with technology?
Well, thank you, Anubhav. It's a very interesting question. And the way I understand things, that technology is moving really fast, and it's just not one technology that we are talking about. We're talking about artificial intelligence, we're talking about blockchain, and it's just the beginning. Wait for a few years, not even a few years, just a couple of years or so, you will start seeing the use cases of quantum computing too. And when the technology is moving so fast, I think it's not fair to expect that a law student or a practitioner should understand technology at a granular level. That does not happen because we are trained in a particular fashion. And the idea is like, how do you approach these markets? How do you approach this technology? The idea is that you should have the basic understanding so that you can sit with a computer scientist, a telecommunication engineer, and based upon the need, they can take you to the nitty-gritty of the issue. So have the basic understanding to appreciate what the other person is bringing to the table. It's just like talking to an economist. When we're doing law and economics, even if you follow the Chicago pattern or the Erasmus pattern, it becomes extremely difficult for lawyers to do hardcore economics and for economists to do hardcore lawyers. It's just that, we develop basic respect for each other's discipline in order to answer to the scholarship. And that's where I think it's important to understand and respect the limitations that we have. That's how actually, at least I understand this developing field of law and technology. Thank you.
Thank you so much. I welcome responses, brief responses to the comments. All right. Okay. Thank you so much. Let me just proceed with my next question then. My next question is for Professor Brownsworth. Professor Brownswood, I had the pleasure of reading your book in the build-up to this conclave and the report. And I'm just going to narrate a small story for the benefit of our audience to understand the context in which I am asking this question. So, in your book, Law 3.0, you have written a short story which is very interesting to explain the disruption of law. And you write that there is a bookstore which faces the dilemma, owing to the, and you quote you say, explosion of new books about new technologies, unquote. The bookstore has a scheme to classify books and accordingly place them. However, there are these new books coming up, AI, nanotechnology, neurotechnology, blockchain, etc., and they are having a difficult time to place them, whether they will fall under popular science, medicine, health, economics, ethics, etc., etc. So the staff realized that it is not possible to find a home for these burgeoning titles on technology, and the existing classificatory indicators are not sufficient. So eventually they give in and they make a separate room, one room in the store which is dedicated to emerging technologies, and everything and anything that remotely pertains to it, you put it in that room. So now extrapolating this short story or this example to legal education, while it may be the easier path to have separate seminar electives for law and tech courses in the seniors year at law school, which is what generally happens, and this is equal to creating a separate room of books. So could you please share your thoughts on ways in which you believe we can integrate the understanding of technology into teaching our traditional or core subjects of law?
Yeah, thanks very much. The big picture is the crucial thing here. And in the bookshop story, you've missed actually the final part of the big picture, because the bookshop, having decided they need a room specially for technology books or a shelf just for technology, now starts asking themselves whether their bricks and mortar store is the most appropriate way or the most efficient way for them to do their business. And they realize that these books that they're now bringing into the store, which cause a classification or shelving problem, are actually talking about opportunities for selling books which don't involve bricks and mortar at all. And the next question for the bookshop is not whether they should have a new room for technology books, but whether they should have an offline store at all or go all online. That's the third part of the story. So I have to excuse the product placement. We don't usually pay much attention as authors to the front cover of our books, but I did choose the image on the front of Law 3.0, which has these three spheres representing the universe of law. And these are Law 1, Law 2, Law 3. And the box we're stuck in is Law 1. Now, each of these spheres, Law 1, Law 2, Law 3, has its own take on what it is to think like a lawyer, because we all assume law schools are about teaching students to think like lawyers. But what that means for Law 1.0 is different to what it means for Law 2.0 and again for Law 3.0. They each have a different answer to that question. And they each have, at the same time, a different answer to the question, how does law relate to technology? And if I may, I'd just briefly like to summarize what the answers to those questions are within each of these spheres and how they understand the relationship. So very quickly, Law 1.0, which, as I say, is the box that we're nearly all stuck in. Thinking like a lawyer is applying traditional legal principles to situations, some of which are very straightforward, some of which are more complex and novel. Okay, sometimes technology appears in these novel situations, but it's not particularly salient or significant. What we're doing all the time is recurring to freedom of contract, sanctity of contract in transactions, recurring to fault in negligence, referring to intent in criminal law. The principles that have served us well, on which are the cornerstones of our basic law subjects. That's what it is to think like a lawyer, thinking about the principles and their applications. How does law relate to technology? Not at all in Law 1.0. If you have a dinner party where a lawyer is sitting next to a technologist, they will not have very much to say to one another, okay? I don't think they have any kind of bridgeheads. Now, in Law 2.0, things change dramatically. Some people would say this is, crucial watershed. In Law 2.0, for the first time, lawyers ask the question, are our rules fit for purpose? They started asking this actually back in the 19th century with railways, where rail crashes were causing death and injury. And the traditional principles were just not suitable at all for compensation or dealing with the risk presented by railroads. So it's an old question, but that thought, is this fit for purpose? Are our rules fit for purpose? Which is sort of precursor of a more regulatory approach, is a key change in our mindsets. And we find so many areas of modern law, like competition law, data protection law, environmental law, company, where the whole thing is driven by policy. It's not just that these laws are typically created in political legislative assemblies rather than in courts. The mindset is policy driven. Okay. Now here, the relationship between law and technology is understood differently, because lawyers thinking in a law 2.0 kind of way understand that technology is salient, is significant, but it's seen as problematic. Lawyers thinking in a law 2.0 way see technologies out there. There's law here, and there are technologies being developed very rapidly out there, coming over the horizon before we know what to do with them, trying to get ourselves set up to engage with them. And then we've just got legislation in place, and whoosh, the technologies have gone somewhere else. I mean, so they're a challenge. Okay, this is the way that that Law 2 sees it. And all the time, what we're focused on in emerging technologies, the challenge is how to have legal frameworks which lay down the appropriate rules for the application of these technologies, but also don't stifle innovation. So the law still, through intellectual property or competition or tax or whatever, gives the kind of support and incentive that entrepreneurs need for beneficial innovation. When we get to Law 3.0, again, there's another sea change in our thinking. Lawyers thinking in a Law 3.0 way will say, what we're training lawyers to do, the way you think like a lawyer, is to think not just about whether the rules are fit for purpose, but whether the rules are the right tools to be using here at all. In Law 1.0, I give the example of drones at Gatwick Airport a couple of years ago, which crippled the airport for a couple of days just before Christmas. People said the regulatory environment is not fit for purpose, meaning we have to change the rules. But as many people also were saying, can't we have some kind of technical solution or technical fix that will deal with the drone problem? Surely the answer is, like with autonomous vehicles for road safety, lies in the design of the product or the automation of the process rather than reliance on rules. So it's not whether we got the right rules, it's whether rules are the right instruments. And the relationship finally between law and technology in Law 3.0 is a relationship now of opportunity and partnership. Okay, so law technology has gone from being, we have nothing to do with one another, from being a problem or a challenge. In Law 3.0, it is now an opportunity, and our relationship with technologists has to be one of partnership. Sure. Now that's how that has to be reflected. If you've got the big picture, if students understand that, you can take them through the curriculum here, there, and everywhere. They will understand why they are having the kind of conversation they're having at any time.
Absolutely. Thank you so much. Brief 30 seconds again. If any of the panelists wants to respond to that, you're welcome, but please, just 30 seconds. All right. Okay. Thank you, Professor Brownsworth. Those are some great comments from you. And I think now we move on to Mr. Mohanty. Mr. Mohanty, my question for you is that you work with policymakers on emerging technologies to design efficient and workable regulatory frameworks. So let me put you today in the shoes of a dean at a law school and ask you, if you were to design a curriculum or a course which is at this intersection of law and technology, or especially, if the students are supposed to appreciate policy around law and tech, then how would you design it, or what would be your method of teaching?
Sure, thanks, Abhinav. I think that's a really thought-provoking question for me, because I'm actively thinking about that. What would that look like? I think I'll break it up into three parts, right? One is the substance. I think two is the methodology, and three is the outcome, right? So I think we want to think about in each of those departments separately. I think let's start with the substance, right? I think just on this panel, but even Professor Brownsworth mentioned, there are different areas of technology, law and policy that I think are fundamental building blocks for understanding how this works. So I think we need to design a curriculum that focuses on issues of, for example, data protection and privacy, on artificial intelligence, on blockchain technologies, So I think different modules around core fundamental concepts of technology are going to be really important. So we can get into the details of that, but I think that's something to think about. And obviously this will have to evolve as new technologies develop. But I would say to start off, I think designing module-based curriculum would be important. Two, and I think this is where I'd like to spend a little more time, I think, talking about, is on the methodology, right? And I think here is, I'll go back to my previous point about how can you make this interesting for students and practically relevant, right? So one is, I think, this idea that we want to be able to use different activities to simulate what's happening in the real world. I think we've heard this often, the lament is often that law school teaching is detached from the practical realities, right? So now having practiced for some time, I think there are a couple of elements that are really important, right? One is really putting yourself in the shoes of different stakeholders in a policy ecosystem. So I like to run mock simulations where, you're asking someone to be in the shoes of the government, right? So you really want to argue from first principles, keeping in mind what different stakeholders might think. And you also want to be able to adopt different different techniques from different disciplines, right? You want to, for example, in a policy negotiation or policy discussion, arrive at not a zero-sum outcome, right? But something that's positive sum, that everyone wins, right? So how do we create a mock simulation where you argue on a debate topic where everyone seems like they've won something? Of course, there are going to be disappointments, but I think that's the kind of policy outcomes that we often arrive at, where everyone's a little bit unhappy, but it serves the larger good, right? So I think mock simulations are one way to do it. Two is, I think, multimedia, right? I spoke about this earlier, about this attention economy. You're competing with, the power of the internet. How can we, rather than be afraid of some of these competing resources, try and adapt them into our curriculum? So, I feel like every module that I spoke about earlier should have an element of pure teaching. It should have, I think, some multimedia component, which is either a podcast or a documentary, something that simulates the fascination of the students. And we're already seeing this happen, but I think just it's important to build this up from ground up and ensure that each module has some of these elements. Three is obviously some of this activity-related, I think, pedagogies, whether it's mock simulations or training programs. Fourth is, I think, understanding that no one instructor has all of the knowledge on a subject or across disciplines. So really inviting more experts, right? Especially in a public policy domain, have on the same issue, have a lawyer, a technologist, an economist, a sociologist, share their perspectives and let the students decide what's the kind of holistic outcome that they want, takeaway that they want from that. So I think that's really important. And lastly, I think, I think this was mentioned in the previous research that's been happening, is I think core communication skills are extremely important for a public policy professional. And I think lawyers have a good underlying fundamental skill, given that you write 50 research papers over the course of 5 years. But I think what's missing is making it practically useful in a way for your audience, right? As a lawyer, your audience is primarily a judge if you're litigating, right? Or for corporate lawyers, perhaps it's the legal department of a company. That's not how it works in the policy domain, right? You're writing for a general audience. It could be as executive of a company. It could be a government bureaucrat. It could be an academic. It could be a journalist. Right? So you really have to break it down to as simple language as you can. So I think that's really important. And the last thing I'll just say is investing in infrastructure is something I mentioned early on in my introductory remarks. And I think that's really where I think law schools really need to start thinking about investing, because there are tools right now that can make the job of a practitioner increasingly interesting, I think, right? Take away the grunt work, this idea of collating all of this information, tracking new legal and policy developments. That should be the prerogative of technology. What law students should be doing is analyzing that and arriving at opinions. So invest in technologies that bring data together, classify this data, digitize this data, maybe even drafting simple briefs that you can then perfect. I really think that's the future, and you'll see in a couple of years there are going to be AI tools that help you, just research topics conversationally. right? With improvements in natural language processing, you'll be able to just speak into your phone and say, what was the most recent Supreme Court judgment on privacy, right? And they'll give you an answer, and you'll be able to respond saying, is that a biter or is that the ratio? And you'll get an answer, and that's where we're headed. So let's think about that from now. Thank you.
Thank you, Mr. Mohanty. And I'll just take a point that you said and sort of flow into my next question. You said that all knowledge, no one particular person or professor can have all knowledge. So there's a greater need for collaboration. So with that, let me just move to Professor Krishnaswamy, and this question pertains to actually the structural problems that universities face in terms of promoting and encouraging collaboration between professionals from different fields. So Professor Krishnaswamy, presently law schools in India face a major challenge in terms of building capacity to offer courses that are at the intersection of law and technology. So, and the majority of the national law universities teach law to the exclusion of other disciplines. Of course, you have a BA LLB and a BBA LLB or BCom LLB, but then it is evident that the component of these BA, BBA or BSc or BCom is very limited. So, further academics are barred from practice, and practitioners who wish to transition into academia full-time have to fulfill requirements that would involve considerable time and effort. It may not even be feasible, considering that the professionals. So recognizing these difficulties, how can law schools in India overcome these challenges and simultaneously provide an environment for collaboration between academics, lawyers, social scientists, and technologists who are working on issues that touch upon technology and policy?
Thanks, Anubhav. A longish question, so I'm not sure I can answer all of it, but let me try in this way. So the creation of national law universities as standalone universities has not helped any of this. The absence of other university departments and the willingness to learn from other university departments has kind of created enclaves of legal education, and the earlier we move away from it, the better. But how might we do it? I guess there are just two ways that organically universities, which may have begun as law universities, develop other disciplinary schools or departments. Or second, that we take cluster university approaches very seriously and ensure that we engage with these other universities substantively. Luckily, in a place like Bangalore, schools of management and schools of science, universities of science, we probably have the #1 universities in both fields. And so we are very intensively engaged in a cluster university approach. And so I think that must happen, and it's just a question of wiring. And we have models, whether that's the East Coast system in the US or Duke, or for that matter, the Cameron McKenna, the California system. So we have systems we can learn from. And so we have to figure a way of doing this and doing this fast. The second element that you seem to ask me was about how do we teach this? And I think I suggested even in the first round of responses that we can't teach it in a law and mode. We have to bring questions of thinking about codes and software to the center of legal education. And here, I mean, I'll just use an example and then come back to point, which is that the COVID-19 virus, the vaccine hunt tells us that you need a lot of very good biology and biochemistry, but some pretty nifty physics to talk about virus structures and good processing ability to work with large volumes of data to even get close to delivering a solution. And we have to learn from these fields and their ability to resolve problems at scale and speed. And we have to ask what might that mean in a law school? And here's what I'm going to suggest, and I'll close with this. That in the question of search, we've more or less focused on teaching people how to use application software well. So we try and teach them the databases, and I think law schools have been doing this for some time. And our students do this less well or reasonably well, depending on what they pick up. But I don't see the option that we must teach students not only to use application software, but to go behind the software. At the very least, they should be able to exploit APIs that databases have, and they should be able to write customized APIs, customized software to use these APIs. If we went a little further, they might even write script to meta tag large document repositories automatically. So I think tagging scripts is very important. All of the digital humanities today does this. There's no reason lawyers shouldn't learn how to do this. And then probably if we push the boat out one step further, we should be writing Python script ourselves and writing search codes that are customized to the problem at hand. Now that you might suggest that this is a bit much, but I think that if we introduce basic coding ability at an early stage of legal education, if you're not going to secede this space to the technologists, then lawyers better learn it themselves. Two more quick points. I think on document generation, at the very least, we use application software. We do that anyway. But I think we can start teaching our students how to automate workflows right away. And these are doable even on current platforms, but maybe if we teach them what this kind of work is, we will get better and better platforms to work with. But low code environments where document creation is automated is a very, very fertile area for work. And I would ideally in 3 to 5 years time, every student who graduated from the National Law School should be able to do low code document workflows. That would be my ambition. Last thing on norm creation, I think we have always thought about norm creation as a sort of, let's get the general principles and then deductively work down to work from first principles to particular applications. And Professor Brownsworth and Amlan have already said something about how we can do this differently. I think, the entire common law theoretical worked from cases and then inductively building principles, but we have probably a different mode, and that mode would be to take kind of game theoretic simulation very seriously. And I think this is both a conceptual rubric as well as a coding rubric. If we're able to use game theoretic simulation well, we have a new mode of norm creation. You have the ability to have some predictive outcomes to the effects of norms. This is all ideas. There's a lot of work to be done on all of these fields, but I suspect that if we don't start now, we will cede more and more space to someone who's just trained in code. Thanks.
Sure. Thank you so much, Professor Krishnaswamy. And although I would have really enjoyed, and I'm sure all our audience would have also appreciated if there was time for greater dialogue and interaction and questions and answers. But unfortunately, we are completely out of time. So my apologies that we'll not be able to take questions today. But I think all of us, this exchange of ideas, and especially the fact that we have started this dialogue as to how we can engage with technology within law school. I think this is a very crucial start and something that we must continue to do on a regular basis. So thank you so much. With that, I conclude the panel. I am really thankful to all the panelists who have joined us, and hope to see all of you very soon, and perhaps we can meet in person once things improve. Thank you so much. Over to you, Mehika.
Thank you, sir. Thank you to all the panelists. It was indeed a very enriching discussion. I would now like to invite our keynote speaker, Mr. Sajjan Puvaya. Mr. Sajjan Puvaya is a designated senior advocate in the Supreme Court of India and has extensive constitutional, corporate, and commercial law practice in the Supreme Court and in various high courts of the country. Prior to his designation, he was the managing partner of Puvaya & Co., a full-service law firm with offices at Bengaluru, Chennai, Mumbai, and New Delhi. He has chaired the Karnataka State Council of the Federation of Indian Chambers of Commerce and Industry, India's apex industry association. He has also officiated as the India co-chair of the New York State Bar Association, Honorary Secretary of the India section of the International Commission of Jurists, and Vice President of the Society of Indian Law Firms. We are glad to have you here, sir, today. Over to you.
Thank you, Mihika. Although I couldn't attend the entirety of the conclave today, but between my hearings in and out of the Supreme Court, I did manage to get glimpses of what was being discussed. For one, I should formally tender an apology. I continue to be robed. That's because I have walked out of a hearing only to finish this dialogue and conversation here and go back to the Supreme Court. So therefore, permit me to continue to be robed as I speak. Let me try and bring something a little different to the table as compared to what has been discussed over this morning. In fact, when Professor Dr. Nigam asked me to speak, I gladly said yes, because I find from my personal experience that there is a dichotomy when we talk of technology and the law. There is a lot. I congratulate BML Munjal University for the initiative. I think you guys are in the forefront in terms of taking this initiative, which is indeed fantastic. But the problem in dichotomy is not in the lack of initiative in terms of seeing how we should redefine legal education, which is a good thing. But the dichotomy stems from the fact as to what is the target when you talk of redefining legal education. And that I come from a personal experience perspective. When we talk of technology and law, traditionally, we have only spoken about technology in terms of the Puritan aspects of technology as to how it is developed. And when I talk of technology here, let's be very clear, we are talking of only two aspects of technology, not the whole world of technology as it is. We are talking of computing technology on the one side, and we are talking of information technology on the other. And I think for a lawyer and for a law student and for general justice dispensation as it is in a democratic economy like, let's say, India, to take that as an example, and in a social situation where there is already a social divide, there is already an economic divide amongst the masses in this country, then what we talk of when we talk of technology and convergence between technology and the law is simply computing technology and information technology. It is anybody's guess that yes, computing technology has developed by meets and bounds over the last, let's say, 2.5, 3 decades. It is also not in dispute that information technology today has really not remained a static platform where you pull down information available from the internet, etc. It has really become a dynamic scenario where you're interacting as you go along. I keep saying colloquially that we, at least most of us, when we were law students, we entered the domain of the law as students of the law even before information technology really matured to a scenario where we could use information technology even in its nascent stage. Most of us didn't even have a dial-up TCP/IP account to send out an email, etc. I think we got it after we got into law school a few years down the line. The first computer I remember as a law student was a massive big box on the table with no space left on the table, but it had a memory of 40 megabytes and it had a random access memory of, I think, 512 kilobytes. And that 40 megabytes of memory was a huge thing. And today we are looking at smartphones which have 1 terabyte of information with computing technology, possibly with random access memory running to multiples of gigabytes, and computing power which is more than a mainframe of IBM. But what does this translate to? This does not simply mean that because there is this great surge in computing technology, we will simply inform our law students about what that surge is, simply make them aware in terms of superficially about what the computing technology genesis has been and how information technologies become interactive, and then let it be. That's really not going to yield results when it comes to the practice of the law. And therefore, let me pitch this from a different perspective. When we talk of interface between law and technology, we should be conscious about two things. One, the interface between law and technology from a substantive aspect of the law is one thing. But the interface between law and technology from the practice of the law is totally another. A lot of attempts that have been made are really oriented towards trying to bring this and build this interface between technology as it is and the substantive aspects of the law. Now, within the substantive aspects of the law, you may really have a social dimension to it. You may have a policy dimension to it. You may simply have a jurisprudential dimension to it. Fair enough. But that does not necessarily translate itself to how technology interfaces with and impacts the practice of the law in a democratic country like India, where diversity is really the key, plurality is the key, and access to justice is the key. Now, from that perspective, I believe that the dialogue that we have initiated now and the paper that you are bringing about the whole design in terms of redesigning legal curriculum, which BMU is really attempting to do, should target on the second aspect of it. For one, we have a whole host of lawyers today, and we have a whole host of academicians in the law, policy makers, etc. Everybody is talking of great surge in computing technology, great surge in nanotechnology, great surge in artificial intelligence. And anybody speaking on artificial intelligence talks about machine learning, deep learning, big data, etc., etc. But we realize, at least as a practitioner, I've realized that when it comes to using it in the practice of the law, very few or nobody really knows how machine learning, big data, and possibly deep learning and artificial intelligence per se will impact in terms of how you are practicing the profession. Forget even docketization, where you will have artificial intelligence running dockets in courts. I'm not even looking at that. I'm simply looking at dealing with a dispute which has an interplay of technology in it. When I talk of a dispute which has an interplay of technology in it, I am not even looking at a Puritan dispute under the Information Technology Act relating to, let us say, a social media intermediary, which is now the flavor of the day. Every social media intermediary seems to be in some form or the other at loggerheads with the so-called governance spectrum today. And we are looking at, every newspaper today at least covers, I think 2/3 of the newspaper is about how social media intermediaries are bad and how the governance spectrum is good. I don't really have anything to say on it because I may be taking one side or the other in court. But compare that to a scenario where, let alone for a minute, let's park the fact that we have Puritan technology disputes that are going on in courts. We will deal with it later. Please look at the other wide area of disputes which are really influenced or in some form or the other nudged by technology today. And therefore, the genesis of the problem and the determination of how the problem should actually be resolved completely changes. But we as practitioners of the law really don't bring anything to bear to make that change. Let me take a very traditional example. Energy disputes when it comes to petroleum and natural gas or electricity, etc., are traditionally decided in electricity tribunals, in commissions, or in the Supreme Court. And the methodology by which they are actually decided has not changed in the last 20, 30 years. Nothing has changed. We use the same skill sets which we had 30 years ago in terms of resolving an energy dispute. And the same thing is brought to bear when we resolve a dispute tomorrow or attempt to resolve a dispute tomorrow. Have lawyers really morphed themselves to being better in terms of this dispute resolution? Have judges really equipped themselves to better resolve this dispute? Answer is no. The same traditional yardstick is applied. But what has changed? An energy dispute which existed 30 years ago to an energy dispute which exists today, there is a whole host of change because there is a technology interface in the way how energy disputes pan out today. For example, traditionally, an energy dispute was really dependent upon documentation in terms of piece of paper, your contracting, etc., and then to see how should you resolve it. But today, you have granular data available in terms of how, for example, an electricity dispute has panned out. That granular data comes, for example, from SCADA, that is the supervisory control and data acquisition system, which every transmission company today will have, with every generating company which will have. And what does it do? Because of the whole host of computing technology that is available, the SCADA data gives you a much more granular picture about the dispute. But do we as lawyers understand that granular picture? Unfortunately, no. We still look at the superficial picture or the overall picture and try and attempt to argue the matter or attempt a resolution at the matter without looking at the granular dispute. Now, why are we not looking at the granular dispute? Simply because we are not equipped to look at the granular dispute, because we don't understand how SCADA technology works. We don't understand how computing technology has been brought to bear in the way an energy dispute can be analyzed. Now, that is what I am talking of when we are looking at practice of the law. Now, what should law schools do? As Professor Krishnaswamy was indicating, I agree. What law schools should do is not really simply look at a theoretical perspective of about how interface and convergence between law and technology can be looked at. It should really look at a curriculum where lawyers who are graduating from the law schools are equipped, let alone to code or to become engineers in terms of software technology and to become experts in nanotechnology. I'm not even looking at that. That's the next level. They should at least be equipped to granularly understand how there is a technological interface in that dispute, and as to why, once you know the technological interface, you can actually bifurcate the dispute into smaller silos and possibly arrive at an easier solution. Now, unless you understand what the dispute is, attempting to actually find a solution is impossible. In most cases, I have realized when it comes to regulatory aspects, airport regulation today, energy regulation, that is electricity regulation, are two examples I will take where the entire matrix has changed because of the convergence of information technology into these areas of traditionally regulated work. Now, when it comes to that issue, because lawyers don't understand technology, they attempt to actually rearrange the problem and then say that, okay, there is a resolution. But yes, traditional wisdom says you don't solve a problem by rearranging it. Now, how do I realize as a lawyer that I'm not solving it and I'm only rearranging it? That genesis and that thought process can come to me only if I understand how technology interfaces with that traditional area of the law. Therefore, from that perspective, I am really, really glad that the initiation is occurring today. Let me come to another dimension to this. We have a larger dimension also when it comes to the social dimension to justice dispensation in this country. Just look at the pandemic, for example. Please look at how justice dispensation is occurring today. Senior counsel like me are attending multiple courts across the country by just jumping between screens and attempting to assist courts in resolving disputes, etc. But what is the percentage of people and what is the nature of disputes that have access to such dispensation? Mostly, it's larger corporate commercial disputes which have access to such dispensation. And when it comes to traditional disputes, when it comes to civil disputes, when it comes to disputes which actually impact the human rights of the last man in the last village, the technological interface has really made no difference. I'm sure during the conversations, one of the speakers brought up this fact, and I agree with that. The fact is that when we are looking at interface between technology and legal practice, please don't look at it from a perspective of saying the Supreme Court of India, a few high courts in the country, few national tribunals in the country have actually adopted technology very well, and justice dispensation is occurring through the virtual mode. Virtual courts are effective, but that's just the tip. When it comes to district courts, and when it comes below the district courts to the civil judges court, when it comes to the junior civil divisions court or the sub judges court, when it comes to really courts at the taluka level, at the town or village level, and upwards to the district levels, the interface between technology and justice dispensation or the practice of the law has been negligible. Now, should law colleges really look at how this must actually first be looked at from a policy perspective and then implemented? Answer is yes. 40 years ago, Dr. Madhav Menon really ushered in courses such as law and poverty, law and urban development. People had really not considered how law and urban development should even become a course to be taught to law students. No, what's this thing of law and urban development? Everybody studied, I'll give you the granular perspective. Everybody, our predecessors prior to the national law schools really ushering in a change in legal education. And mind you, even that change is now 4 decades old. But prior to that 4-decade-old change in legal education being ushered in, everybody read the Land Acquisition Act, because the Land Acquisition Act is almost, at that point of time, was almost a century old. Now, everybody looked at what the Land Acquisition Act said, but nobody really mapped how the Land Acquisition Act or the Land Reforms Act impacted urban development, and as to how certain aspects of social significance in terms of having clean air, water, sanitation, etc., really impacted in the way the Land Acquisition Act was being really applied towards acquiring large land parcels. What is the interface between the Town and Country Planning Act and the Land Acquisition Act? What is the interface between the Reforms Act and the Land Acquisition Act? That was the granular perspective which came in when a course like urban development and law came up. Now, that is the need of the hour today. Please look at even the Information Technology Act we have today is archaic. The technology has marched on. We were at Web 1.0, which was static interface between the internet and the human being. We are now at Web 2.0, where there is a dynamic interface in terms of information download from the internet to the human being. We have still not got onto a scenario where the Internet of Things really develops. Now, just look at a situation where in India, if Internet of Things really were to usher in, and you're having a scenario where my car is talking to my house is talking to my refrigerator is talking to the supermarket. And from that perspective, my entire ecosystem is today in some form or the other manipulated or at least governed, a semblance of governance, governed by artificial intelligence. How does a lawyer even look at a dispute that emanates in that ecosystem? We are lost. Lawyers with experience of multiple decades on the technology spectrum are lost. Now, how do you then expect a law student who's really coming out of a law school to be ready in terms of saying that, yes, I am ready, I am a warrior, I have my weapons, and therefore I can go to war today. I don't need separate training. Therefore, when we look at, it's a great attempt that BMU is doing, but please don't stop this attempt from a policy perspective or just from an academic to technology interface perspective. The dimensions that map themselves out when we are looking at practice of the law and change in the society, digital divide and general change in society, to how technology can be brought in as an interface to make practice of the law more efficient. Justice dispensation more efficient is the key. Yes, would one conclave really get us the answer? No, absolutely not. But would that one conclave put in the seed which will actually be germane for a greater discussion and panning out in terms of the right policies? Answer is yes. I will stop with one statement. Most disputes today, as we read the newspaper, between large internet players and large internet intermediaries and multiple governments across the country, whether it is India, whether it's United States of America, whether it is UK, whether it is Ireland, whether it is France, Australia, New Zealand, the same disputes are continuing. The same dispute about why a social media intermediary should or should not be governed in a particular manner. It's not unique only to India. I ask myself the question, with so much of computing power that we have, so much of technological advances that we have had on the Puritan perspective, should we have the same kind of disputes across the globe and no solution? The answer is this. To my knowledge, I may be right, I may be wrong, but my understanding is we are having these disputes because people in the governance spectrum, that is people in the general country or state governance spectrum, and people in the justice dispensation spectrum simply don't understand technology. And because we do not, we think we understand technology, but we do not understand it from a granular perspective. And because we have a lacking in our understanding, the same nature of disputes emanates everywhere. And to find a solution, we still attempt to find a solution through the law and not find a solution through the interface between law and technology. So how far will this take us? And what's the qualitative level of the solution? Only time can tell. But I'm so glad that the initiative has begun. And I think including more number of practitioners in this entire exercise and making this dialogue between academia and the practitioners of the law in the justice dispensation mechanism more closer and more converged, I think will be the way to go forward in terms of ensuring that we have a lasting solution, or at least a very dynamic solution which will march with technology. You know, everybody talks about how sectors have been redefined by technology. Answer is not just traditional sectors being redefined by technology. Traditional sectors have been disrupted by technology. Our understanding should not be simply to look at a policy framework as to how technology has redefined the way work is done. We should really look at it one step ahead. Please see how technology has disrupted the way the work is done. And when that disruptive technology brings about a newer methodology by which a traditional activity is done, law really should look at it from a different perspective. With those comments, I will stop, because I can on this aspect go on till the cows come home, and I'll be very happy to, of course, continue this dialogue with BMU at any point in time and take this process forward and contribute in whatever way we can. And thank you very much for giving me this opportunity to speak. The panelists who spoke earlier are all people who are certainly more qualified than me to speak on this area. But I really thought it is not, I'm not here because I'm any more qualified than anybody. Really, I'm not. But I really thought I could bring a different perspective to it, because in the last 15 years, I've been seeing how technology disputes are panning out in this country. And unfortunately, they're really not improving in terms of how those disputes are resolved. Thank you very much.
Thank you so much for your words, sir, and thank you so much for being a part of our conclave. And now I would like to introduce Dr. Preetam Barua, Dean School of Law, BML Munjal University. Dr. Barua is a seasoned academic and researcher with an experience of more than 15 years. He holds degrees in law from Nalsar University of Law, University of Oxford, and University College London. Previously, Dr. Barua taught at the National University of Judicial Sciences, Kolkata, and O.P. Jindal University. He was a teaching fellow at University College London and has held visiting professorships at the University of Ottawa, China University of Politics and Law, NLSIU Bangalore, and Humboldt University Berlin. Sir, I would like to invite you to give the concluding note.
Thank you very much. I would request the host to enable my video, please, because I can't do it at my end. Thank you very much. So thank you. I must thank, our keynote speaker and all the panelists for what I think is breaking new ground on how legal education should respond to the development of technology. As I listened to the panelists today and to the keynote by Mr. Puvaya, I saw that not only is there agreement that there should be serious thought put in to how technology impacts the legal system, but also how we should prepare our students to be ready to participate in a legal system which is increasingly being not infiltrated, but impacted by technology. And as Professor Bronswood showed us, that the relationship between law and technology has been taught by lawyers, not recently, but since Law 2.0 for a long time now. But this is the manner in which we engage with it which has to change. And today I say that we have broken some new ground because we already have in place some structure of what legal education can do. For example, we saw that everybody recognizes the importance of having technology-focused courses, but also the manner in which these courses should be designed. For example, we have agreed on foundational courses that familiarize our students with the law. We could have electives which are more practice-oriented or once interest-oriented, which can really prepare our students to practice the law and see the law and technology interfaces. But what I think is also important is that we have recognized that just as several other domains of the world, for example, the environment, or for example, gender, that permeate our lives in ways which we refuse to recognize for a long time, technology has also got that hallowed status, I guess, in some ways, where we must recognize the ways in which technology has seeped into the life of law in diverse ways. So I do think that some of the big picture questions that came up today, for example, Mr. Mathan raised the question of that we should not rule out AI systems judging, taking the place of judges in the future. And Professor Krishnaswamy pushing us to say that law students should actually learn some amount of, not just some amount of coding, but even advanced systems, and for them to be relevant. And I think that these big questions are important. And I'm happy to say that some theorists have anticipated these as long back as in the 1970s. So there was a cognitive scientist, Fred I. Dretske, who spoke about something which I think what Professor Krishnaswamy and then later on Mr. Puvaya spoke about, makes it very relevant. So he said that, and he was a proponent of the computational theory of the mind, that all thinking is computational, which was later made famous by the philosopher Jerry Fodor. But the computational theory of the mind has real relevance to what technology can do in actual legal disputes. Those things that are purely computational can be done by technology. But we have to reflect as lawyers, that is judging really only computational, or is it something more? So it makes us rethink about what we are doing as lawyers and law academics and judges. But what is interesting is that Professor Krishnaswamy said that we should be teaching them coding and they should know the computational techniques. And somewhere I think Mr. Puvaya also said that we should even know how information is stored. So these disputes can be appreciated in a much more granular way if we know how the information is stored and which information is useful for dispute resolution. And Dretske had said long time back that there are these two aspects to technology. One is that it operates on information, so we must know information. And the other is that it computes, and we must know computing. And I think that today we have got material to think about this in a really fine-grained way, that when we introduce courses, foundational courses on technology, what do we teach our law students? Is it only computing? Is it awareness? Or is it teaching them how information is stored by advanced systems and how lawyers can access and work with them? And I think all of these are really important questions which will guide the way forward for at least our law schools and perhaps several others of how we can reform the curriculum. I'm happy to say that at the BML Munjal School of Law, we already have scientists and managers teaching our students, and it is our plan that there will be pan-university courses where every student is taught technology in a way which is useful for them by experts who know the area, for example, artificial intelligence or coding. And it gives us, and I'm really thankful to the panelists today for giving us these ideas on the basis of which we can structure the curriculum and on the basis of which we can lay the foundations for curriculum 3.0, as Dr. Nigam says it, and make our law curriculum much more relevant for our students. So I'll stop here. And again, I must thank Vahura and the entire team that has organized the conclave, and especially our panelists for supporting us in this endeavor. And I look forward to being in touch with you and interacting on this issue more, so that we can make this a reality in terms of making our curriculum more sensitive to technology. So thank you very much, and over to you, Mihika.
Thank you so much, sir. And with this, we conclude the Law Conclave 2021. We hope you enjoyed the session. We look forward to many such engaging sessions going forward. On behalf of BML Munjal University and Vahura, I, Mihika Mukherjee, would like to thank each one of our speakers, our dignitaries, guests, colleagues, and friends from the legal fraternity for having been with us today. Should you have any questions, please feel free to write back to us on our official email IDs. Thanking all of you once more. Stay safe and stay connected.